had a full house in our registration, so not sure what's happening, but we'll allow them to come in quietly. So good afternoon, everyone. Thank you so much for being here. This marks our 6th consultation with civil society leading up to our engagement with the UN Human Rights Committee for our 5th periodic report on the International Covenant for Civil and Political Rights. Your presence and input in this process have been really invaluable to us and have greatly informed our understanding of the pressing issues addressed in the report. So I want to thank you at the outset. For those of you I haven't had the pleasure of meeting, and some of you I know, I'm Ambassador Michelle Taylor, the permanent representative of the United States to the UN Human Rights Council, and I also have the honor of being the head of our delegation for this review. We have a pretty large delegation, as you can see, representing key parts of the U.S. government, including senior representatives from the National Security Council and the Domestic Policy Council, as well as Mayor Stephen Reed of Montgomery, Alabama, and Attorney General Aaron Ford of Nevada. As deep and as broad as this delegation is in its leadership, I really want to emphasize that we're here to listen today, and to, of course, answer the questions that you want answered, but mostly we're here to listen and to let you all drive the conversation. I've said many times in the UN Human Rights Council chamber and publicly that no country is above scrutiny, and that includes my own, the United States. And that's why we place so much value on this process and why we encourage other countries to join us in our transparency. As you know, I'm sure we're celebrating the 75th anniversary of the Universal Declaration of Human Rights this year. And that was the seminal document that laid the groundwork for the ICCPR, reaffirming humanity's faith in human rights and in the dignity and worth of all human beings and the equal rights of men and women. That process was led by my predecessor in this job, Eleanor Roosevelt. So I feel a tremendous responsibility personally to carry out that legacy. And that's what we're doing here today. The US government recognizes the monumental role that civil society plays. You're not just observers or commentators, you're an integral part of our shared collective, relentlessly, sometimes, pushing us toward a more just society. In doing so, you compel us to be answerable to our greatest commitment, and that is serving the American people. Every insight, every recommendation you offer helps shape our path forward. And I hope that this engagement today extends well beyond these walls and this time period. We're really honored that Justin Vail, the Special Assistant to the President for Democracy and Civil Participation on the Domestic Policy Council, is here with us today and will be with me on the dais as we engage the committee on the report. His presence here really, I think, further demonstrates the United States' commitment to these issues and to this process. So thank you, Justin, for taking the time to come to Geneva. Before we start our discussion, and I want to dig right in because I know we don't have a lot of time and we want to give you as much opportunity as possible. While this session has been by invitation, we consider it to be on the record. So just want to make that clear. As you know, it's being recorded and webcast live to your colleagues and to broader civil society audience. As you can see, we also have a photographer in the back, Eric, taking pictures of the program. We'll be glad to make photos available later this evening or tomorrow morning that your organizations will be able to use. To ensure that as many of you as possible have the chance to raise your issues and allow for a robust exchange between all of us, we're asking each speaker to limit yourself to no more than 2 minutes and 1 question per person. And Tim over there is going to be our time minder, so be ready just in case he might have to give you a little warning. We do have 2 microphones in the room, and we ask that if you have a question, please come and wait at one of the microphones. I'll be going back and forth and taking questions. If you're physically not able or comfortable going up to the microphone, please get Tim's attention and he can bring you a wireless microphone. We'll get through as many questions as we can, but we'll also be glad to continue our conversation informally at the reception after the program. So we're really looking forward to that opportunity to have a little bit more informal conversation. I just also really want to let folks know that we will not be taking a break during the approximately 2-hour session. So if you need to use the facilities, please feel free to do so at your own convenience. You will not be rude. You do not need to worry about getting up. Part of the reason is we want to be able to give you as much time as possible. And also we just don't have enough facilities to take one break. It would take too long to get everyone through at the same time. And that would take away from your valuable time. So with that, I would love to start opening it up to questions. So please feel free to stand at the microphones and we'll call on you when ready. I know this is not a shy group. Yeah.
I want to start up. My name is Dr. Koch from Germany, but I'm representing the US group, the Leonard Peltier Ad Hoc Committee. And my questions are targeted to bring more attention, awareness to the case of this 70 years old and 40-year-old prisoner who is now 40 years in prison. I had a couple of questions, not to one person, just for the whole group, because I'm studying the case of Mr. Peltier now on 25 years. And yeah, I start. For example, how could it be ignored that the former supervisor of the prosecution, James Reynolds in this case, wrote to President Biden, "I write to you that I have come to realize that the prosecution and continued imprisonment of this Mr. Peltier was and is unjust." Another question, how could the US government allow the violation in context with the extradition from Mr. Peltier from Canada, like extortion and coercion of false testimony under threat of violence? I gave a handout to Ms. Bender that the delegation has the chance to see my background informations and information sources and some more detailed facts. Why was in 1995 parole hearing examiner Robinson determined that Robinson replaced after he determined that Mr. Peltier should be released on the faulty ballistic evidence alone? That lead that Mr. Peltier's release was denied by a new parole examiner who gave the order for this replacement. There were, in the whole case, a lot of defects of trial contributed to Mr. Peltier's conviction. I listed a lot of them in my handout that I hope would be shared here for the delegation. How could all those unlawful violations of justice taking praxis in this case?
We're at about 2 minutes.
One last? Okay. Why is Mr. Peltier still in prison after the new report of the UN Human Rights Council Working Group of Arbitrary Detention shows that the civil and human rights of Mr. Peltier were violated and that he is in arbitrary detention? In the final statement are enough reasons of importance for Mr. Peltier's release, also listed in my handout. Please take the time, just maybe reading 8 minutes to read the handout I gave as Ms. Bender. Thank you very much.
Yes, Fanula Tessier from the Department of Justice. Mr. Peltier is an enrolled member of the Turtle Mountain Band of Chippewa Indians of North Dakota. He's 77 years old, and he experiences diabetes, hypertension, partial blindness from a stroke, and recently COVID-19. We understand he was forcibly removed from his family and Indian tribe to enter an Indian school from 1952 to 1955, a federal Indian boarding school that has been officially acknowledged by the Department of the Interior in the Federal Indian Boarding School Initiative Investigative Report by the Assistant Secretary of Indian Affairs. I understand that elected officials and former officials, international figures, have requested for clemency to be granted to Mr. Peltier, including former U.S. Attorney James Reynolds, whose office handled the criminal prosecution and subsequent appeal of Mr. Peltier, 11 members of Congress, Pope Francis, the Dalai Lama, Nelson Mandela, and Archbishop Desmond Tutu. I also know that the United Nations Human Rights Council, working on arbitrary detention, has called for his release. He was convicted by a jury and sentenced in 1977 to 2 consecutive terms of life imprisonment for aiding and abetting crimes against 2 FBI agents, resulting in their deaths. And a federal court of appeals has upheld his conviction and sentence on 4 separate occasions, most recently in 2006. In 1994, the U.S. Parole Commission denied Mr. Peltier parole following a full hearing. And in 2009, he was afforded another full hearing before the U.S. Parole Commission, which also denied him parole. His next scheduled parole hearing is in July 2024. Absent an earlier parole, his current projected release date is October 11th, 2040. Then President Ronald Reagan denied his first clemency petition in 1982. He filed a second petition in 1989, which was administratively closed due to then pending litigation challenging his conviction and sentence, which was upheld. President George Bush denied his third clemency petition in 2009. He was eligible for a 4th time in 2010 and filed a new clemency petition that was denied in 2017. He filed his 5th clemency petition on July 20th, 2021. It is the president who has the plenary power to pardon or commute federal sentences. And within the Department of Justice, the pardon attorney is responsible for receiving and reviewing petitions for executive clemency, initiating and directing necessary investigations, and preparing the department's recommendation for submission to the president. The pardon attorney reviews each application and conducts the appropriate investigation in the case. Letters sent in support of clemency for a particular individual are part of the individual's clemency file. The pardon attorney considers many things when deciding whether to recommend that the president grant a pardon, including the disparity or undue severity of the sentence, critical illness or old age, and meritorious service rendered to the government. A combination of these and other equitable factors, such as demonstrated rehabilitation while in custody or exigent unforeseen circumstances, may also provide basis for a recommendation. After the pardon attorney's recommendation is made, it's submitted to the Deputy Attorney General, who then makes the final recommendation to the President. My understanding is that Mr. Peltier's petition is currently pending. Because it is currently pending, I cannot comment on further on whether or not it will be granted, but that is the process that it will go through. Thank you.
Thank you. Next.
Very much. Good afternoon. I'm Margaret Huang with the Southern Poverty Law Center. I have one question for federal representatives and one for one of your local representatives. I hope you'll allow me if I stay within the time. I also want to appreciate the space you've created here, but note that it is insufficient. We have a number of colleagues who were not able to attend this briefing, who traveled a long way in hopes of meeting with all of you. So I hope that you will consider in the future identifying a space that could accommodate all of the civil society representatives who've joined us here in Geneva. My first question is around the White House executive order on addressing extremism in law enforcement. This was the May 2022 executive order on law enforcement. We have been waiting for quite some time from a few different agencies to understand how this commitment is being enforced. We had an excellent meeting with the Department of Homeland Security, Office of Civil Rights and Civil Liberties last week, and we know that there is a commitment to look at the question of how the policy will be implemented for those large law enforcement agencies like CBP in DHS. But we are still waiting for a response from the Department of Defense, I'm glad you're here, about the senior official who's been charged with addressing extremism in the military. And so we'd welcome an update from all law enforcement agencies on how this executive order is being implemented. For my local question, that is for Mayor Reed from Montgomery, Alabama. It's nice to see you on the other side of the world. Mayor Reed, as you know, this year, the Alabama State Legislature passed a law prohibiting loitering on public streets, despite numerous court decisions across the United States that declare that asking for help is not a crime. I'd like to know how you're intending to implement this law in Montgomery, and whether you have an update for us on the task force that you've established to address problems of the unhoused and how you're moving forward on that front. Thank you all for your time.
I'm Deborah Plunkett, Department of Defense, Office of the General Counsel. So I don't know all the specifics about how that particular initiative is being implemented, but as a member of the executive branch, we do take presidential guidance directly into hand. And my understanding is that with policy guidance from the Office of the Secretary of Defense, the individual services are putting in place measures to try to combat the, as we've all noted, the level of extremism in the military. It is something that has been a concern for a long time, and it is something that's being monitored, especially through trying to keep tabs on the individuals who've spoken out and who are showing hostility towards their fellow troops in particular. So I'm sorry I can't speak with more specificity on that because unfortunately our colleagues who are more steeped in that issue aren't with us today, but thank you for your thoughtful question. I can give you my contact information, ma'am, but I couldn't tell you who that is right now.
Good afternoon. I'm Stephen Reed, Mayor of Montgomery, Alabama. I want to thank Mario for the question and thank her for the work that the Southern Poverty Law Center does around the country. As it relates to our legislature passing laws that relates to loitering, as a city, that's not our primary focus to enforce that. What we're trying to do really dovetails into your second question around the task force that we created on homelessness. We're really trying to connect the unhoused with resources and support that they may need, whether that is through mental health, substance abuse, but also housing as well. One of the things that has come about as a great creation of our task force on homelessness is we actually have homeless providers talking now. And it's something that as the African American Mayors Association, we're doing nationally under the leadership of Los Angeles Mayor Karen Bass. We're trying to make sure that there's not duplication of services and that we're adopting best practices. So for a mid-sized city like Montgomery, who may not have the presence of a large city in terms of the homeless population, what we're trying to do is to make sure that whether it be through relatives, whether it be through faith leaders, that we're connecting those who are temporarily or long-term unhoused, get support and know exactly where to go and how to reach out in order to get that help. We're also doing quarterly counts, which we'll probably change to more bi-monthly counts, for the homeless population. And we want to make sure that for those that are veterans, because we're finding a disproportionate amount are veterans, they're connected with the type of services that many of them don't know that they have access to. So the benefit of the task force has been, one, we've identified some of the issues. We have people now collaborating who are working in their own silos. And now third, we can bring about more government support to help them, help those who really are in need. And I think that is the most important part as opposed to our state legislature passing more laws that don't really address the problems that we have already in our cities.
And if I may add to that, just very briefly, Demetri McCain, Office of Fair Housing and Equal Opportunity at HUD. We have issued lots of guidance and what have you, so that people can figure out, cities and other locations can figure out ways to actually assist in the issue instead of criminalizing homelessness. Actually, our annual continuum of care grants that we give out, we incentivize those organizations to figure out ways to create some tools and policies that are an alternative to the criminalization of homelessness. So I just wanted to add that.
Can I make a recommendation that we go on the honor system and you all kind of know where you are in line, and so that folks don't have to feel like they have to stand up the whole time. So please feel free to sit down. Just remember where, like, who you were behind. Go ahead.
Afternoon. I think my question is best addressed by Department of Justice or Department of Education. My name is Miriam Haskell. I'm a civil rights attorney in Florida. And I mean, I could go on and on and on about Florida, but what I do want to focus on is public education And the fact that we have seen classroom book bans, curriculum standards change, entire departments at public colleges and universities be erased because they're described as, as woke and indoctrination. And I think what my clients and community members in Florida want to ask you all is where's the federal government? Where are folks at DOJ when it comes to intervening, and how, or at DOE when we're talking about OCR complaints, and if necessary, in the friendliest way, like how can we help you help us, because we need it in Florida.
I'll jump in first, and thank you so much for the question. I'll start with, we investigate every complaint that we receive.
Introduce yourself, please.
Sorry, I'm Catherine Lehman. I'm Assistant Secretary for Civil Rights at the Department of Education. We investigate every complaint we receive. So the best way to help us help you is to complain to us so that we can investigate if you have a concern about civil rights. We do have many investigations pending in Florida on the topics that you raise. And separate and apart from the Office for Civil Rights, active enforcement on the civil rights issues there, we also are investigating accreditation for Florida universities and evaluating what other steps might be available to us. But we have recently issued guidance as recently as last August related to curriculum bans in schools and book bans. We've resolved cases on the topic, and we are very eager to ensure full satisfaction of civil rights for every student in every state who needs us.
And I'll just, I'm Jonathan Smith, Deputy Assistant Attorney General for the Civil Rights Division at the U.S. Department of Justice. Within the Civil Rights Division, we have an educational opportunities section that works very closely with Catherine and her team in the Office of Civil Rights to make sure that the jurisdiction that we have under Title IV of the Civil Rights Act of 1964, Title VI, and our other authorities are used as aggressively and proactively as possible. One of the ways in which we can get involved, in addition to joining investigations or filing litigation, is also filing statements of interest in cases where we can articulate the concerns from the federal government or from the Justice Department. And I'm happy afterwards to give you my card. And if there are cases or situations where you think potential statements of interest or other DOJ involvement might be helpful, I'm happy to chat about that and also connect you with my colleagues back in the U.S.
Couple comments on the Guantanamo detention facility and post 9/11 U.S. torture more broadly. And to the extent it's helpful, my colleague Alka is going to address different aspects of the same issue set if you want to take them all at once. First, transfers out of Guantanamo. I urge you not to delay any forthcoming significant additional progress on transfers out, whether on the basis of external events or otherwise. Time is really of the essence and momentum is important. Second, use of torture-tainted evidence in the Guantanamo military commissions. The government needs an across-the-board policy that prohibits using or defending the use of any such evidence in any proceeding for any purpose. DoD General Counsel's office, to your credit, I think has taken some important steps towards that end, but they've been a bit case by case, and the problem is not gone away. So an across-the-board policy solution, I think, is really necessary. And then lastly, victims of post 9/11 U.S. torture have a right to redress and rehabilitation, right? All of the issues I'm talking about right now are covered by multiple articles of the ICCPR. I am not aware, having worked on these issues for many years, of a really sort of meaningful, led to tangible steps conversation about redress and rehabilitation within the government. And I hope that's something that we might be able to talk about together going forward. Thank you.
Same topic. Do you want to go ahead and take your time now?
Alka Pradhan. I'm actually at the Military Commissions Defense Organization, so I am a DoD employee, and I represent one of the 9/11 defendants in the 9/11 case that's been in pretrial hearings for about 11 years now. But what I actually want to drill down now on is what Scott was referring to, which is the effects of torture and the issue of medical care at Guantanamo. For some years now, I've worked at Guantanamo for a decade. For some years, we've heard the population described as geriatric, as aging, and prematurely. So, right, not just from the length of time they've spent under extraordinarily harsh conditions, amounting to CIDT at a minimum at Guantanamo, but also from their previous torture, either at Guantanamo or at the CIA black sites, like one of my clients. And so we have seen a real deterioration in recent years. Some of you may be familiar with the fact that one detainee has had 6 spinal surgeries at Guantanamo, several of which have occurred because the first several were done wrong, because we do not have the ability to conduct complex medical care at Guantanamo, per the former chief medical officer who testified last year. My client has multiple traumatic brain injuries and recently was diagnosed with a spinal tumor, although we cannot figure out what kind of tumor because the MRI is not working down there. As recently, the real issue is that secrecy has always been prioritized at Guantanamo over the care of the men. And that was actually confirmed just last week by the Joint Task Force Commander upon cross-examination, who confirmed that everything within the minds of these men that would contribute to taking a proper medical history remains classified at the top secret level. And so that drastically reduces the pool of medical providers that we are able to bring to Guantanamo and treat these men. So there is, what I really want to ask is, what is the plan for implementing independent medical care at Guantanamo, which is grossly needed per the Special Rapporteur's report recently? And otherwise, what is the plan to transfer the men specifically to places where they can obtain such medical care, which is a departure from the way transfers have occurred in the past? Thanks.
Hi, Deb Plunkett again from Department of Defense. If you don't mind, I'll take the second part of your question first. That is one of the things that I was told to anticipate we'd be asked about today, is medical care with certain individuals. Probably expect that I won't be able to speak to any particular cases. We do have some issues that are ongoing, and that's an area of sensitivity. But I was told to inform you that DoD is in fact committed to providing appropriate medical care for detainees at Joint Task Force Guantanamo. They're making every effort to make sure that fully qualified individuals are available. And if detainees develop medical conditions that are beyond their capabilities, specialists or equipment to address those conditions will be brought to Joint Task Force Guantanamo. Currently, under law, we are prohibited, the Department of Defense is prohibited from bringing any of the Guantanamo detainees to the United States for any reason, which will include medical treatment. Therefore, we have to bring the specialists and equipment out to Guantanamo and to meet the needs of the population. Joint medical group providers take very seriously their duty to protect the physical and mental health of the detained persons and approach their interactions with those persons in a manner that it seeks to allow them to build that doctor-patient bond of trust and rapport, and to encourage their participation in medical treatment in their counseling sessions. We are told that the healthcare that's currently being provided is comparable to that which the military personnel themselves received. And I understand that there's some concern that you have. If you have additional information that you want me to take back, I would be happy to do so. Thank you. And I'm sorry, your initial question, you were expressing strong support, I understand, for the idea of effecting the transfers as soon as possible, if that's correct. You're not concerned about the current environment. You want the message going back to be that you want us to proceed with all due speed to effect those transfers. So the main message to you is that right now, the primary concern in effecting transfers is making sure that they are safe transfers and that we will have appropriate assurances from whatever countries and facilities agree to take the folks in our ongoing positions. Thank you.
And then he also had a question about the intelligence obtained. He had a question about the intelligence obtained.
I made a note when you asked your question about, excuse me, about the need for an overarching policy that speaks specifically to that. As you know, there is no express promulgated policy on that at the moment. I will take that note back, and I thank you for your thoughtful question.
Thank you. My name is Ian Manuel, At 13 years old, I was arrested and sentenced to life without parole. I was sent to an adult prison, and soon after I got there, I was placed in long-term solitary confinement, which the state of Florida defines as close management. I would remain in solitary confinement for 18 consecutive years, from November 1992 to November 2010, from age 15 to age 33. According to a recent report, at least 120,000 people in the U.S. are being held in solitary confinement on any given day. Contrary to what the U.S. reports, solitary is not rarely used, and it is not used only when absolutely necessary. It is routine. Growing up in solitary confinement in the United States was difficult. I was kept in a small cell the size of a walk-in closet or bathroom. I was beaten and abused by sadistic correctional officers. The security would spray us with high-powered chemical agents and gas that took most of the oxygen out of the cell, making it difficult to breathe. If the chemical agents got on your skin, it would burn for hours, making you feel like you were being roasted alive. Sometimes we'd be tied to our beds and forced to have psychotropic medications injected into our buttocks to torture us. Other times they give us stitches without anesthesia to deliberately hurt us and as a deterrent to discourage us from attempting suicide. I testified at the UN the other day concerning these issues, and they thought I was talking about a third world country, not the United States of America. To stand here in Geneva and express some of these things that I've went through is shocking to the public conscience, but it's something I lived through. I remember being in solitary, hearing the outrage about Abu Ghraib going on in Iraq when the same thing was occurring in U.S. prison systems. And it's horrifying that these atrocities would happen in this modern society, let alone the USA. In 2012, I testified via transcript at a hearing chaired by Senator Dick Durbin about solitary confinement. Afterwards, President Obama enacted a presidential order that immediately eliminated solitary confinement for juveniles at a federal level. Currently, there's a bill pending. I want to know if the White House is committed to support the End Solitary Confinement Act and to immediately implement strict time limits for any type of solitary confinement in the U.S. I also asked for commitments from the Department of Justice to step up investigations on the conditions of solitary confinement units in state prisons. I have two friends right now in the state of Florida that have been in solitary confinement for 25 years. And I would love some type of answers concerning them. Thank you.
Thank you so much for sharing your story. I read about your testimony this week, and I was very grateful for it. I can imagine that it's been very difficult to speak publicly about this repeatedly, and we're very grateful that you go through that so that we can know and understand. So thank you. I would like to talk briefly just about both excessive incarceration of juveniles, and also I can talk a little bit about solitary confinement in the federal system. We know that more than 2 decades of research have shown us that confinement negatively impacts youth, mental and physical health, and increases rate of reoffending. As a result, many states have significantly reduced their incarcerated youth populations and begun to explore ways to reinvest savings into more effective community-based alternatives. The Department of Justice Office of Juvenile Justice and Delinquency Prevention Community-Based Alternatives to Youth Incarceration Initiative supports states closing large youth detention facilities and supports efforts to reinvest resources in ways that sustain more effective community-based services for justice-involved youth and their families. There has been, specifically on the issue of life without parole for juveniles, there has been some development in the law, and the Supreme Court ruled in Graham versus Florida that you cannot have life without parole for non-homicide crimes committed as a juvenile, and in Miller versus Alabama, that life without parole cannot be mandatory for juveniles. And in Montgomery versus Louisiana, the rule in Miller was applied retroactively. So it's an issue that we're continuing to work on, but I do think we've seen some improvement in that score. As to the issue of solitary confinement at the Bureau of Prisons, well, so for correctional facilities generally, including at both at the state and local level and at the federal level, the Constitution prohibits the use of seclusion in a manner that constitutes cruel and unusual punishment. Federal prisons are under the jurisdiction of the Department of Justice, the Attorney General through the Bureau of Prisons. And on May 25th, 2022, the president issued an executive order that requires the Attorney General to report to the president steps to limit the use of restrictive housing and to improve conditions of confinement. And the Attorney General did issue a February 2023 report on steps taken to ensure that restrictive housing is used rarely, applied fairly, and subject to reasonable constraints. That individuals in Department of Justice custody are housed in the least restrictive setting necessary for their safety, the safety of staff, other prisoners and detainees, and the public, and to ensure the Department of Justice full implementation of a 2016 report and recommendation concerning the use of restrictive housing. In response to that report, the Bureau of Prisons has updated its policies and developed alternatives to solitary confinement, including more reintegration units and secure mental health units. Both the Bureau of Prisons and the Department of Justice are committed to further addressing and reducing the use of restrictive housing. Bureau of Prisons has worked with the National Institute of Justice on a study to review and provide recommendations regarding the Bureau of Prisons' use of restrictive housing. And the Bureau of Prisons recently assembled a task force of senior Bureau officials to conduct a near-term assessment and provide more immediate recommendations for steps that Bureau of Prisons might take regarding restrictive housing. I think my colleague can speak a little bit more about our work with state and locals.
Yeah, I'll be really brief because I know there's a lot of questions. Just very quickly, in the Civil Rights Division, we have authority to enforce the Civil Rights Institutionalized Persons, or CRIPA, Persons Act, CRIPA, as well as other federal laws that are designed to ensure that people in prisons and jails are treated in accordance with the Constitution. We have placed a premium and a focus on doing more work, focus on prison conditions. We've opened an investigation and have litigation against the state of Alabama. We recently settled litigation investigation into a prison in the state of New Jersey. To the extent that there are other prison systems or facilities that are particularly troubling, again, I'm happy to give my card, and we're happy to hear recommendations or suggestions about other places where we can enforce our authorities.
Thank you so much, Madam Ambassador. My name is Aaron Ford. I am the Attorney General for the state of Nevada. Mr. Emanuel, was it? Thank you so much for your testimony, your question. I've had to engage on this issue for several years in several different capacities. As a law clerk, I recalled in 2003 advising a judge on a case coming out of Arizona where a leader of the Aryan Brotherhood had been in solitary confinement for decades. And the question was an Eighth Amendment question of whether or not it was cruel and unusual punishment. He was released before we had to issue the decision, but I recall having to think on that issue from several different perspectives. And I thought about it from a state Senate perspective when I was in the state Senate, and now as Attorney General working in this issue as well. What I can say from a Nevada perspective, I don't purport to speak on behalf of any of the state at this juncture, but we have in fact taken seriously this issue. We have eradicated and eliminated the ability for solitary confinement to be used in the juvenile context. We have limited, just this last go around, legislative session, limited the use of solitary confinement. Let me read my notes so that I don't misstate it here, but we have determined that it should be used, if at all, sparingly and with restrictions. And I believe, frankly, that it shouldn't be used with juveniles in any event. But this year, our legislature passed restrictions on the use of solitary confinement so as to lessen the impact that it can have on inmates by ensuring that it's used as a last resort and for the shortest period of time that is safely possible. Inmates in Nevada, barring extreme circumstances, cannot be placed in solitary confinement for any more than 15 days and cannot be placed in solitary within 90 days of their release date. And they cannot be placed in solitary confinement if they have a mental health issue unless the mental health issue provider orders such confinement. We know that solitary confinement hinders mental health recovery and can cause issues with readjustment to society. So we've also put safeguards into effect to help with this. And finally, I'll say that those inmates in Nevada who are placed in solitary confinement are also allowed access to visitation and a telephone. And they can receive a daily health and welfare check from healthcare professionals as well. So we've made great strides in the state of Nevada to try to address this issue based on our belief that solitary confinement, if at all used, should be used sparingly. Thank you again for sharing your story, sir.
Thank you. I'm Justin Vale from the Domestic Policy Council. I thank you for raising this legislation. I do not believe we have taken a position, but I will certainly take this back to the White House, and we appreciate you raising it here with us today.
Good afternoon. My name is Reverend Kiana Jones. I am here with Community Movement Builders as a part of civil society, and I represent the movement to stop Cop City. I came here from Atlanta, Georgia. Right now, my reality is that I live in a place where protest has been criminalized. I live in a place where environmental racism has taken a hold of my community, where the city of Atlanta has been allowed to take hold of 381 acres of forest land. With a critical watershed within that land, they have been allowed to begin to demolish that land with 2 schools right near it, and also 3 juvenile prisons right behind it. They are seeking to build a $90 million militarized police training facility in order to practice urban warfare, wherein they will continue the police terror of a Black community where I was born and raised, that's been the victim of environmental racism since the 60s in the city of Atlanta, Georgia. Environmental racism to the point that they are currently violating the Clean Water Act, and the regional EPA will not even answer our phone calls. Environmental racism to the point that there's a police firing range that's operated 24 hours a day. I had to move because my 8-year-old, who I homeschool, could not take the sound of gunfire morning, noon, and night. To this day, my 8-year-old, if he hears a loud bang, will hit the floor or try to hide behind me. I'm also living in a reality where 61 of my comrades have been charged with either domestic terrorism and or RICO charges for simply disagreeing with the government, for simply daring to say we will not allow our land to be taken because Black people deserve green space too. Black people deserve to breathe clean air too. Black people deserve water that is not contaminated with lead, and our children deserve to be able to think critically without gunfire in the distance as they're at recess. But because somebody decided to sit in a tent with their hands raised while cops raided the forest, they were murdered with 57 bullet holes. My question, and I want a real answer. I don't want anything that's been prepared because I know you didn't think about it because you may not have written it. I want an answer. Will the U.S. government investigate the murder, the first ever murder of a U.S. climate justice advocate by U.S. police? Will you investigate the murder of Manuel Esteban Paez Terán, known as Tortuguita, and will you ensure that people have a First Amendment right to redress of grievances through protest without having to fear RICO charges simply because they said stop Cop City?
Thank you for the question, and I recognize that. Well, let me start by saying, in our Constitution, in fact, in the First Amendment of our Constitution, there's the recognition that all people in the United States have the right to peaceably assemble, to petition the government, and to seek redress of grievances. And I know personally as an African American that history of protest, that history of sit-ins, of movements is why our democracy, while far from perfect, is much better today than it was at the start of the American experiment. And within the Justice Department, we are committed to making sure that regardless of where people live in the country, regardless of the issue or the challenge, that they are free from police or law enforcement activities that violate their rights. Now, I will say, and I make clear that certainly law enforcement officers have a really important role to make sure that protests or any activity are done lawfully and within the bounds of whatever rules may apply. But we also recognize that law enforcement officers can and have crossed that line. We have, for example, we have issued findings and taken action against the Portland office, Portland, Oregon Police Bureau for their response to protests following some of related to George Floyd and some of the other racial justice issues. We recently, in the Civil Rights Division, issued findings against both the Louisville Metropolitan Police Department based on their response to the Breonna Taylor situation. We also made findings related against the Minneapolis Police Department following the George Floyd protests. In both of those findings reports, which are publicly available and on our website, we specifically called out the ways in which Louisville in the first and Minneapolis in the second responded to, and we believe violated the rights of protesters in those respective jurisdictions. And we're currently working with both of those jurisdictions to enter consent orders that hopefully will cure those practices. We also more recently we issued a report that are also on our website that our COPS office, our Office for Community-Oriented Policing Services, released, which was done after a series of consultations with civil society, with law enforcement leaders about how to make sure that protest activity is done in a way that comports with the law. And not just the law, I mean, I read the First Amendment, but it's not just about, you have this constitutional right. It's about the fact, as I said before, that protest is essential to our democracy, and it's really critically important that we recognize and respect that. I unfortunately can't talk about any specific matters or investigations. I'm happy to talk with you offline or after this about that. But I hear you. I know that it's incredibly frustrating. I know particularly the Cop City issues are incredibly frustrating, and know that we at DOJ, we hear that. We are committed to addressing this issue, and we will do what we can within our jurisdiction to be responsive.
Bamese, Ensumba, Abene Binham Neo Wule, Fitokida Brasamada Sipiwe Baleka. I greeted you in the language of my Balanta ancestors, including my fifth-generation great-grandfather, who was captured as an 8-year-old boy in his village of Unche in the country of Guinea-Bissau, trafficked across the Atlantic, and subjected to chattel enslavement in the United States, which resulted in ethnocide. There are now documented 6,534 Balanta people that were trafficked to the United States, and an estimated minimum of 30,000 of us. Not only did I greet you in my ancestral language, I wore an article of our traditional clothing, which according to the 1740 Negro law in South Carolina, I would be subject to up to 40 whippings on my back for possessing. I now live in my ancestral homeland. I have repatriated, the first of my family to return after 250 years of living in the land of our captivity in the United States. I am the living example that it is possible to recover from United States state-sanctioned ethnocide. I have the following questions. What remedies are available to the Balanta people in America for redress of ethnocide? 2, will the government of the United States engage the government of the Republic of Guinea-Bissau to negotiate our voluntary repatriation? Question 3, how can the Balanta Brasa History and Genealogy Society in America, of which I am the president, how can we engage in the process of receiving reparations for the crimes of chattel slavery and ethnocide in the United States?
That's 2 minutes.
And my last question, well, I'll just leave it with those 3. Thank you.
I just wanted to go back to the question about some of the environmental issues in Atlanta.
Can you introduce yourself, please?
I'm sorry. I'm Kareem Marshall. I'm the Senior Advisor for Environmental Justice and External Civil Rights at the U.S. Environmental Protection Agency. So I'm alarmed to hear that one of our regions hasn't responded to you, so I'll get your information at the end of this so that we can close that loop. Secondarily, as you all know, as a federal system, permitting can be a complicated process. So I'd like to follow up with you to talk about how we can better coordinate because we have expanded a lot of our efforts to work with our partners in states to make sure that they are adhering to the delegated authority that's provided by our act. So I just want to make sure we close that loop. Thank you. Thank you.
I guess it's me again. So first, thank you for the question. From the DOJ perspective, I could talk about our work around trafficking and how we are committed to responding to that. And I defer to other agencies about some of the kind of non-domestic aspects of your question. I guess I want to start by saying that we are committed to being responding to human trafficking and using all of the tools that we have available to be responsive there. In fact, in January of last year, the department released our national strategy to combat human trafficking, which is designed not only to prevent trafficking, but is also committed to the prosecution of human trafficking, the protection of victims and survivors, and the partnerships at every level of government. And we are actually working in close coordination with our colleagues at the Department of Homeland Security, colleagues of the Department of Labor and elsewhere to make sure that we are being as responsive and utilizing a whole of government approach here. I think that in terms of some of the specific kind of questions and flags that you raised about voluntary repatriation, again, that's not something that we have within our statutory authority in terms of the prosecution of human trafficking cases. But what we can do and what we are committed to doing is making sure that we hold perpetrators of trafficking accountable through our justice system, whether that's through criminal prosecutions, whether that's through the use of our civil authorities to be responsive. And we're also really committed to making sure that victims are addressed to the extent that the federal law allows. Again, there's not any we don't have any federal authority at the Justice Department as it pertains to reparations. And so again, I can't be responsive to that concern, but to the extent that there are ways that we can help make victims of any federal crime, including trafficking, whole, we have an Office of Victim Services that's committed to that. And certainly we're happy to have further conversations about ways in which we could, within, again, our authorities, be more responsive to the concerns of your community and to all communities. Thank you.
I would like to thank you again for sharing your story and the questions. I'd like to offer a brief response to say this Richard does acknowledge the history Black American under this administration government working to advance justice and equity. Address the last on his first day in office, executive order, government, this executive, so full of government. That all Americans.
Could you speak into the mic for the webcast?
Aware that Congress is considering legislation that would establish a study of reparations. We think that Congress is the appropriate venue for consideration of such action, and we will continue to monitor that. I want to thank you again for your comments today.
Thank you, Attorney General.
Thank you so much. Again, Aaron Ford, Attorney General from Nevada. First, let me say how delightful it is to hear that you've been able to trace your heritage back and your roots to the continent. I've endeavored to do that, and I keep getting stuck somewhere in Alabama, right? And I don't mean that in jest. It's a difficult task, and it's one that unfortunately many of us are unable to complete because of our history of chattel slavery. What I'm going to respond, how I'm going to respond is going to be entirely unsatisfactory to you. Because you're asking about reparations, and you're asking about an approach that has been an age-old conversation for years. And while we wait on the federal government, as has been indicated, for Congress to act in this regard, I'll just point you to some of the things that other municipalities are doing. San Francisco, as an example, has enacted, I believe it's San Francisco, or maybe it's the county itself, has enacted a policy related to reparations that might give you some guidance or some suggestions and ideas on how to proceed in that regard. But as you know, this is an age-old conversation around reparations, among other things you've asked about. And just on this point in particular, I just want to say, I commend you again for continuing to pursue this issue, and congratulate you on being able to trace your heritage back in that regard. And I just encourage you to continue moving forward with this questioning.
If I may, real quick, can someone address the issue of ethnocide that I raised?
I again want to thank you for your comments, and we take them with great seriousness. I will take this back and we will give it consideration to the extent that ethnocide is a crime. I think the Department of Justice gave the comments that they're able to offer, but if any of my other colleagues want to speak to this. Thank you.
Good afternoon. My name is Stanley Bellamy. I'm a community organizer with RAP, Releasing Aging People in Prison, and a member organization to the People's Campaign for Parole Justice. In 1987, at the age of 24, I was sentenced to 62.5 years to life. In April 24th, 2023, after serving 37.5 years of that sentence, I was released. Thankfully, because the governor found mercy and granted me clemency. Otherwise, I would be serving 25 more years in prison. I have only been home 6 months. So accordingly, I'm here to talk to you about what we consider death by incarceration sentences. And death by incarceration refers to life without parole, life with parole, and virtual life imprisonment. These sentences effectively condemn people to permanent incarceration. In the United States, over 200,000 people, or 15% of the prison population, are serving these sentences. 46% of those sentenced to death by incarceration are Black, although 14% of the total U.S. population is Black. The increasing reliance on death by incarceration sentence has led to the creation of nursing homes behind bars. For example, there are 56,000 people serving life without parole in the United States. Almost half of them are 50 years old or 60 and older. And when I'm talking to you about death by incarceration, I was serving a death by incarceration sentence. Had the governor not granted me clemency, I would not see the board until 2048, when I would be 85 years old. In New York State, the average age of somebody living or dying in prison is 57 years old and 58 years old. So I was not going to survive this sentence without the governor intervening. So the question I'm asking to you, what is the United States government going to do or is doing to end these death by incarceration sentences? Because we talk about Miller versus Alabama, but you're sentencing 18-year-old kids, and you're sentencing them to life without parole, but you're also giving them consecutive sentence. You've taken 17-year-olds when you said Miller versus Alabama that says you can no longer give a 17-year-old and younger life without parole.
There were 2 minutes.
All right, but you're giving them these type of death by incarceration sentence by giving them consecutive sentences. And I hope you understand what that means because my time is running up. So what is you doing to end these type of sentences in the United States? That's my question to you.
Much. And again, we really appreciate those of you who are particularly sharing personal stories. And thank you for doing that. the United States has made it a priority to support sentencing reform and to particularly to reduce racial and ethnic disparities in sentencing at all levels of the criminal justice system. And we know that that disparities exist in the system and that there are sentences that are too long. The United States Sentencing Commission, which is an independent body in the judicial branch, collects and analyzes sentencing data at the federal level, and has specifically found that controlling for type of offense and other important factors that Black men receive longer sentences than white offenders. And we know that this is a problem. The department has advocated to the Sentencing Commission to address systemic sentencing reform in the coming years, which reflects the president's commitment to criminal justice reform. Several other specific things to talk about. In 2022, the Attorney General issued a new charging policy requiring federal prosecutors make an individualized assessment when deciding what charges fit the circumstances. And this policy disfavors the use of mandatory minimum sentencing, which we understand has been one of the reasons that has driven sentences so long. It also expressly directs prosecutors not to use the discredited statutes applicable to crack cocaine offenses at the federal level, which disproportionately affected Black men. Regarding federal cocaine sentencing more broadly, the administration has advocated for passing the Equal Act to eliminate the remaining statutory disparity between crack and powder, and we support applying such changes retroactively for defendants who are already sentenced. We also have implemented the First Step Act, which is, and continue to implement it, one of the most significant criminal justice reform bills in recent decades. Among other things, that bill reduced mandatory minimum sentences for certain drug offenses and expanded courts' ability to sentence low-level nonviolent drug offenders below mandatory minimum sentences. It made the Fair Sentencing Act retroactive. That was the 2010 act that had reduced the disparity between crack and cocaine, but not eliminated it. And 91% of the defendants who were resentenced under the retroactivity provisions of the First Step Act were Black. There are also sort of broader efforts at permitted additional reductions in lengthy sentences. The Sentencing Commission recently voted to expand the availability of sentence reductions for those serving unusually long sentences. It also expanded the applicability of the medical circumstances provision for compassionate release. So compassionate release is it's a federal statute that has long allowed individuals to apply for a sentence reduction because they are elderly or suffering from medical issues. The First Step Act, so the decision whether to reduce a sentence is with the sentencing court, but the First Step Act allowed defendants to apply directly to the sentencing court for a reduction. And that resulted in a large number of grants of reductions of sentences at the federal level. And the Sentencing Commission recently voted to expand the applicability of that under the sentencing guidelines. And that should, absent action by Congress, should go into effect on November 1st. We also, the United States Congress has introduced legislation that would allow for federal prisoners to seek sentence reductions, and a number of states have also adopted these so-called second look provisions. And federal legislation has also been introduced that would also establish or support programs that divert individuals from incarceration, eliminate policies driving excessive imprisonment, including repealing additional mandatory penalties, cap sentences, mandate review of sentences. So there's a lot of legislation that's being considered and some that has passed at the state level. And as I also mentioned earlier, of course, there's the work that the Office of Juvenile Justice and Delinquency Prevention has done to reduce incarceration of juveniles. This is an important topic. It's one that we take very seriously, and there's a lot of work going on. And we hope that we will continue to make improvements in this area.
One other driving force that you did not mention about these sentences, the felony murder count. need to talk about the felony murder count, because individuals is getting sentenced to these lengthy sentences when they are not the so-called perpetrator. I can be sitting in the car, I drive him to the store, he goes in the store, robs somebody, and I get the same sentence as him, because that felony murder count drives mass incarceration. That needs to be addressed.
Well, I can say at the federal level, the Attorney General's charging policy that was issued in 2022 directs prosecutors to make decisions based on the individual circumstances. And so to make sure that the charges that are being brought at the federal level really reflect the seriousness of the person's individual actions. I can't speak more generally about the felony murder rule. I think a lot of what you're talking about is also at the state level. And it's, we have a federalist system. And so a lot of prosecution is done at the state level. And of course, the Department of Justice takes seriously our obligations to work with our state and local partners. I can speak primarily to how we do things at the federal level. I don't know if either Mayor Reed or Attorney General Ford would like to speak on that.
Well, speaking of the state level, my name is Aaron Ford again, Attorney General for Nevada. I won't be speaking to the felony murder rule. That's a legislative, issue. I can tell you, I don't suspect they have any desire to change that, frankly. But to your point, I just wanted to respond to a couple of your questions. To your question related to what you call death sentencing, I think is death by incarceration. So one of the first things I did when I came into office was to issue a criminal justice reform policy that, for example, removes the ability for us, doesn't remove it, but certainly limits our approach to stacking charges, for example, to ensure that we have fairer sentencing in that regard. We do have compassionate release at the state level in Nevada. We utilized it, frankly, a little bit more during COVID, as an example. When I was in the state Senate, we passed a sentencing commission, which now looks at the laws to determine whether we need to adjust some of the sentencing factors that we utilize and some of the terms that we use. We've gotten rid of juvenile life without the possibility of parole sentencing, and we did this years before. Years ago. I sit on the pardons board right now, me, the 7 justices of the Supreme Court, and the governor, and we do oftentimes commute sentences and grant pardons similar to the clemency you received. I sit on the board that provides that same clemency, and so we take into account what people have done in prison during their time in prison to make determinations on whether they should receive their clemency, and we offer it a lot more than I would have contemplated, frankly. I will close by a couple of statistics, because I agree with you that we have some racial disparities as well. In Nevada, Black people only account for 9% of Nevada's total population, but we account for 30% of our prison population and 32% of the population in our jails. And so looking at statistics like this just drives me as an African-American Attorney General, top law enforcement officer in my state, to be a little more dedicated to looking at these things and trying to find redress and reforms to address some of these inequities. And so thank you again for sharing your story.
Good afternoon. My name is Lisa Borden. I'm a senior policy counsel at the Southern Poverty Law Center, and my question is going to be asked on behalf of the growing campaign for a national human rights institution. I'd say my question is largely directed to Justin Vail, but may draw a comment from anyone. Last year at the review by the UN Committee on the Elimination of Racial Discrimination, two commitments that I want to mention were made. The first one was that the administration would, in fact, consider the need for a national human rights institution. And the second one was that the consultations that had been done with civil society leading up to that review were only the beginning, and that there would be real engagement with civil society about the implementation of that committee's recommendations. And I stand here today concerned about whether this committee's recommendations, the Human Rights Committee's recommendations, will receive that kind of engagement, because the surge recommendations did not. We did attempt to follow up, and I'd like to say that this growing campaign for National Human Rights Institution, we have been privileged to work with a wonderful group of organizations with pivotal leadership from the American Civil Liberties Union. We have, along with them, made a number of efforts to follow up both on consideration of the NHRI as well as when were we going to get some engagement about the CERD recommendations? When were we going to have these follow-up consultations? There had been talk about a convening of civil society that never materialized. I do want to acknowledge that there have been some agencies that at least my organization has been able to approach separately to talk about CERD recommendations, and that have been receptive. Catherine Lehman at the Department of Education, I recommend that everybody follow her lead on being receptive and enthusiastic about trying to do something about recommendations that come from the UN. HUD, for another example, we've had some good discussions with HUD. But these exceptions kind of prove the rule that there is no infrastructure, there is no systematic effort to actually implement the ratified treaties or the recommendations that come from these bodies.
We're past 2 minutes.
Okay, and so what we'd like to know is what commitments are going to be made to the committee during the review to actually make progress on the committee's, the commitments that were made last year, and what steps will actually be taken to fulfill the commitment to consider the National Human Rights Institution. Our coalition has proposed a presidential commission to study it. We'd like to know whether anything's going to be done about that, and what engagement is going to happen after this review so that we can actually talk to you about the recommendations that come and how they should be implemented. Thank you.
Thank you, Lisa. So the United States remains committed to effective domestic implementation of its obligations under human rights treaties to which it is a party, including the Covenant and the CERD. Since day one of this administration, across the government, we have been working steadfastly to honor and to implement our human rights obligations. And as you see, we are taking this process seriously, and we look forward to continuing this discussion about the progress we've made and the challenges left ahead. There are a number of ways in which we are ensuring that our domestic policy development and implementation reflects our obligations and is informed by these processes and ongoing input through these international processes and other forums, because we think it is very critical that our policy development and implementation reflect the voices of the community, particularly underserved communities, and the administration is taking a number of actions to improve that. I cannot make any specific commitments today regarding the nature of the ongoing dialogue for the Covenant, but I look forward to having that conversation with you to make sure that you have access to us and we have forums to keep this dialogue going. We are aware and appreciate, as you said, the ongoing information and advocacy that you are making regarding the establishment of a federal national human rights institution. As I said before, although we do not have an official human rights institution, we have multiple complementary protections and mechanisms to enforce our ability to guarantee respect for human rights, including through our independent judiciary at both the federal and state levels, and numerous state and local human rights institutions. We welcome continued discussions about how we can improve this. And to the extent that the president has authority to establish such a body, the administration will continue to take these recommendations under advisement. We look forward to exploring these discussions, but as of now, we have no additional information regarding the establishment of a national human rights institution.
One thing in follow-up. There was recently a one-year follow-up report to the CERD that was submitted by the U.S. government, which we found out by finding it on the UN website. And there was not, as far as we know, and as far as everybody that we have here to talk about, any engagement with civil society, even about that 1-year follow-up? And I really would like to know why.
Again, we didn't have a formal consultation to produce the 1-year follow-up report, but I think we have multiple forums and engagement throughout the interagency because we are committed to making sure that civil society's voice is heard in our policymaking process. We can do better. We strive to do better. And thank you for raising that lack of engagement for the report. I appreciate your advocacy here.
I can't speak to your question about the institution, but I will speak very briefly that, setting policy by way of engaging with people who are closest to the ground, closest impacted, is a real best practice. And that's what we're trying to practice. And so we have met numerous times with in various listening sessions with lots of grassroots organizations, people with lived expertise, and we will continue to do that. We've met with not just your organization who was here during CERT, but others as well. And I will be happy to provide any kind of contact information during the reception period.
Hey y'all, how's it going? Happy to see you here. My name is Nick Stelter. I'm with the Miami Law Human Rights Clinic, and I want to talk to you a little bit about like transgender rights. So I'm sure you all figured that was coming at some point. But I obviously don't want to rehash any ground that like you already know about because it's everywhere, it's in the news. So I'm just gonna like go through some stuff and then you just nod your head if you know what I'm talking about, and I'll move on to the next thing. So drag bans, we're all pretty familiar with that. We've seen it. Okay, great. The bathroom bans, that's been going on for a couple of years. Only just recently did they get successful, but they have been here for a while. Don't say gay bills, obviously, don't say gay or trans. It's a pretty big issue in the public school system right now. And then really tied to that is the healthcare bans for minors who are seeking hormone therapy. Again, it's one of those things that I'm pretty sure we're all kind of familiar with. One thing that you might not know about is in the state level legislature over in Montana, the transgender legislator who was speaking out against one of these healthcare bans was actually banned from speaking in the session. It's also, pretty big deal for ICCPR. So yeah, I guess, we're all pretty aware of it. So with that, I'm just gonna read you some stuff that I said today at the session. But it's nice to know that everyone knows what I'm talking about. So, while these violations have been happening, the federal government refuses to stop states from violating our rights enshrined in the ICCPR. Why has the federal government refused to act in the face of book bans that seek to erase the existence of the LGBTQ+ community? Why has the federal government refused to act when state employees are prohibited from discussing their identity? Why has the federal government refused to act when states ban life-saving medical care?
That's 2 minutes.
And I worry that once we do actually have the federal government's attention, that it's going to be too late for a lot of these citizens who are being politically targeted at the moment. So my question for you as the committee is, how can we heal from some of these violations that have been committed by states? And then further, how can we prevent other minority groups from being targeted like this again in the future? Because we know it's going to happen.
I'll jump in and just say I share, and I know the entire administration shares the passion that you bring to this issue and the urgency. I want to just note, we have not refused to act. We have acted to protect students with respect to book bans in a southern state, and we are still investigating that topic. We have announced an interpretation of Title IX to guarantee that the sex discrimination law does apply to all persons, including transgender and non-binary persons. And I just want to emphasize that we very recently entered into a resolution agreement under Title IX as it exists now, without having had an amended and new regulation made final, which we are also working on. But under the law as it exists now, we have acted to protect a non-binary student in school. We issued a press release about it. We're very aggressive about making sure that all school communities know how we apply the law and that we will be there for every kid who needs us in any school every day. So I am 1,000,000,000% with you about the concern that you have, the concern in the area that is within my control at the Department of Education. I know that the president, I know that all my colleagues at this table are with you also across the other jurisdictional areas as well. And any minute that someone lives without the rights protected is a minute too long. And we are serious about reducing that quantum of minutes.
If I could just jump in quickly from the Justice Department. First of all, I agree with everything that Catherine said, and this has been just a horrifically terrible year, particularly in regards to just the just unbelievable number of not only bills that have passed that you mentioned at the state level, but also just the number of bills that have been proposed. And I was actually just yesterday talking to a doctor who provides gender affirming care to transgender youth, and she was telling me about just the threats to her physical safety, the threats that other providers, that parents, that young people face, and we know that that is not only unlawful, it's just simply unacceptable, and it's heartbreaking that so many people are afraid for their safety just because of who they are. And so we also, like the Department of Education, are using all of the tools that we have available at the Justice Department. The issue of physical safety, we are working both with the Civil Rights Division as well as our colleagues at the FBI to make sure that we investigate and prosecute hate crimes that are directed towards LGBTQI plus individuals and providers. We recently secured a successful prosecution of someone who, a man from Texas who threatened a doctor in Massachusetts. We were able to address that concern. We also are working with community organizations. We actually just 2 weeks ago had a meeting where we invited community organizations from across the country to the Justice Department, where we talked about how to what efforts we could take to give additional physical safety and security to health clinics, to gay bars, to the full range of institutions that we know are under assault. We have filed a number of litigations and legal briefs in support in challenging gender affirming care bans. We were actually successful in achieving 2 preliminary injunctions. Those have recently been stayed by appellate courts, but we are aggressively and eagerly, or not eagerly, but we are aggressively and proactively going after state level bans. We've also filed briefs in support of, for example, transgender students who were denied access to bathrooms, access to sports teams consistent with their gender identity. And so we are committed to doing all that we can. If there's more that we can do, we want to hear from you because we agree with you. It's unacceptable. And certainly we are committed to using all of our legal federal authorities to be responsive to that.
And I would love to add just a little bit more. Hi, I'm Jess Marcella from the Department of Health and Human Services. So thank you for your commentary. I'm also the director of the Office of Adolescent Health. So as many of those bans rolled out with respect to banning gender affirming care for young people, one of the primary responsibilities that we felt at HHS was that we needed to combat misinformation and disinformation specific to gender affirming care, and so put out a series of materials with respect to that. My boss, Admiral Rachel Levine, is the highest ranking trans woman in the US government and is obviously a huge proponent, an advocate from where we sit within the department and in every space. And so all is to say, we have been working on non-discrimination in healthcare delivery. We have worked closely with providers to make sure that trans young people are getting sort of the appropriate care that they need and that providers have the resources, technical assistance, and training in that effort, and that the chilling effect that we're seeing from these bans is mitigated to the extent possible. So thank you for raising this issue and really look forward to having more conversations about the ways in which we can continue to support people.
Very much.
Thank you. 30 seconds is what I've asked for. I'm glad to hear my federal colleagues point out that not only is it not that nothing is being done, in fact, it's just the opposite. There's a lot being done at the federal level, but at the state level as well. As attorneys general, a little less than half of us, and let you count up why that is, are signing on to these briefs or filing lawsuits that are challenging these bathroom bans, the sports bans, you name it. And so there's an advocacy around trans issues that is happening at the state level as well. And I, as Attorney General, want to mention that for the edification of this body.
Hello, my name is Shaga Zakarian, and I'm here representing the Khalid Jabara Foundation and the Jabara family. Khalid Jabara was shot and killed in a hate crime in Tulsa, Oklahoma, after more than 5 years of terrorization by their next-door neighbor. This neighbor ran over Khalid's mother, Haifa, who's here in Geneva with us, 8 months prior, was charged and released after 6 months for that crime on bail, free to live next door to the Jabara home, at a home with a firearm. Weeks later, Khalid was murdered at the steps of his home. I'm also here speaking for Taylor Dumpson, who is also in Geneva but could not register for this event. The day after Taylor began her role as an elected student body president at American University, nooses hanging bananas appeared throughout her campus. She was then doxxed by an online white supremacy group with her personal information made visible and available for intense harassment and attacks. While Taylor's story is horrific, it is unfortunately not at all unique. Online social media accounts exist with the sole purpose to spread hate and terrorize citizens online and off, with few avenues for accountability. While our organization is proud to have worked to pass the Jabara Hire No Hate Act, the first hate crime legislation to pass in America, it is not enough, and hate crimes continue to rise. The prevalence of firearms and the ease of access to them, and the rapid evolution of technology and the amplification of extremist ideologies and harassment through online platforms that go unchecked have created new avenues for hate to spread very easily. As recently as yesterday, a 6-year-old boy, Palestinian American boy, was killed by a white supremacist, white man in Illinois in an Islamophobic hate crime following the conflict in the Middle East. Our question is, what are you doing to combat hate speech, radicalization, and extremism, especially online through private company platforms like Facebook, Twitter, or X, and its direct link to violence and hate crimes that culminate?
So, again, the situation with hate crimes in America is also unacceptable. And, as many of you likely know, recent data shows that the number of reported hate crimes are at the highest level in decades. And we know that those are only the incidents that we know about. We know that there are far, far, far more incidents that never get reported to law enforcement due to for a range of reasons. I did want to, just quickly on the really tragic killing of the young child yesterday, the Attorney General issued a statement. We are investigating that as a federal hate crime, as the Attorney General's statement makes clear. The Attorney General of the United States, just because I know there's another Attorney General here, as Attorney General Garland made clear in his statement, we are that's unacceptable. That no one should be targeted in such a manner, regardless of where they come from. And we are committed not only to fully and fairly investigating that matter, but we are also committed to working with community leaders, particularly community leaders that may feel at risk given some of the situations happening around the world. In fact, I got a text message from one such leader while on this panel talking about, what can we do to be responsive? And so, yes, we hear you and happy to have that conversation very quickly because I know we don't have a lot of time, and happy to talk more offline. This is the highest priority of the work that one of the highest priorities that we're doing at DOJ. The first act that Attorney General Garland took as Attorney General was about increasing our hate crimes enforcement. We are bringing, dozens and dozens of prosecutions in the Civil Rights Division. We are holding public forums. In fact, your family and Taylor spoke at a forum that we had a few months back. We are doing community education programs. We've rolled out a program, United Against Hate, which is present in all 94 of our U.S. attorneys' offices, which are designed to educate the public about the reporting and response to hate crimes. And we're doing all of that, and we know that the numbers are still going up, and that's clear that there's more we need to do. So we hear you. It's tragic. It's unacceptable, and we want to continue to talk about how we can continue to increase our response.
I just want to say briefly, too, that the United States took up the chair position of the Freedom Online Coalition, which is an international group of countries that have committed to protecting human rights online as well as offline. And I think that speaks to the dedication that this administration has to looking at not only existing technologies, but also emerging technologies as platforms for violations of human rights. Thank you.
I just wanted to add that in your question, you also mentioned the link to possession of weapons and gun violence. And I just wanted to make the point that addressing gun violence is a top priority for the Department of Justice. And we support and we've continued to push for common sense gun legislation. And so we understand that it gets particularly bad when guns are involved. And the administration is committed to common sense gun legislation.
Hello. Oh, thank you. My name is Clay Notes with the Miami Law Human Rights Clinic. So the right to non-refoulement is found in the Refugee Convention, the Torture Convention, and Articles 6 and 7 of the ICCPR as interpreted by the committee. Despite this fact, the U.S. continues to deport non-citizens in violation of the right to non-refoulement, and in a manner that is especially cruel towards Black non-citizens deriving from countries like Haiti, Cameroon, and other majority Black nations. As it relates to Haiti, the U.S. continues deportations to Haiti despite the fact that it continues to designate Haiti for temporary protected status and has advised its own citizens to evacuate the country for safety concerns. The U.S. usually carries out these deportations in a manner that is designed to avoid their international human rights obligations through maritime interdictions in the Caribbean Sea or pushbacks at the U.S.-Mexico border or agreements with third countries such as Mexico. My question for you all is, how does the U.S. regard the right to non-refoulement as articulated in its international obligations? And further, what are the avenues to address the rights abuses perpetrated against individuals who are deported from the U.S.? Thank you.
Thank you for your question.
Introduce yourself, please.
I'm sorry. Thank you. I'm Royce Murray. I'm the senior counselor to the Secretary of Homeland Security at the Department of Homeland Security. I appreciate your question and want to say unequivocally that the Department of Homeland Security respects the obligation to not return individuals to a place where they fear persecution on account of a protected ground or torture out of respect for the Convention Against Torture. You raised a number of questions very specifically about Haitians, Cameroonians, maritime interdictions, pushbacks at the southwest border. Sort of in reverse order, I obviously want to make clear we do not have pushbacks at the southwest border. You may be referring to Title 42, the CDC's public health authority that was in place.
Just on that point, with the CBP-1 app, asylum seekers who enter through the southern border have to wait in Mexico and schedule an appointment, and there's a number of problems with that app. And the facial recognition of that app is racially discriminatory to the point where individuals who would like to schedule an appointment to enter the U.S. through legal pathways are unable to do so because of their race. And and there's been reports of appointments to legally enter the United States that happen hundreds of miles away. How is that a fair opportunity? That's essentially the same as the Remain in Mexico protocol, except with extra steps.
I want to make sure you've had an opportunity to complete your question. I don't want to interrupt you.
No, you say it doesn't exist, but effectively it does. It's a legal fiction to say it doesn't.
So I'm happy to talk about the CBP1 app. The Biden administration is very committed to expanding lawful pathways to avoid the use of smugglers and cartels that absolutely take advantage of migrants who are on the move for any one of a number of reasons. The use of the CBP1 mobile app has been introduced this year for scheduling appointments for people to present themselves at one of 8 ports of entry along the southwest border. We have, at this point, 1,450 appointments each and every day. That's been in place since July 1st, with 1,000 appointments a day backing up to earlier this year. It has worked very well, not without its glitches, and we have worked very hard to iterate and make improvements in the app. I will note that Haitian nationals have been one of the top 2 or 3, but certainly I believe one of the top 2 nationalities to successfully use CBP1. So any actual issues related to glitches we have found often related to lighting, Wi-Fi issues that we have tried to get out better guidance on and make adjustments in the app so that there are not racial disparities in the use of CBP1. We have seen it used effectively, and Haitians are certainly not the only individuals using it. We have wanted to incentivize the ability to be able to come through ports of entry, which has been a primary ask of the advocacy community for many years. I'm familiar with that because I was on that side of that table not very long ago. Just regarding the pushbacks, certainly CBP1 is part of the Circumvention of Lawful Pathways rule, which again is conditions asylum eligibility on having used, the CBP1 app and scheduled an appointment. But individuals who are subject to that presumption are still able to apply and are not otherwise accepted from the presumption are eligible to apply for withholding of removal, which, as you know, implements our obligations to not return individuals to persecution on account of a protected ground. And just finally, just since you mentioned pushbacks and the returns of Haitians and Cameroonians, as you know, the Title 42 Public Health Authority that directed us to expel individuals at the southwest border was lifted on May 12th following the lifting of the public health emergency. At this time, individuals who present themselves, whether or not through the CBP1 app, are given a screening for their protection concerns, either through expedited removal or in proceedings before an immigration judge. And finally, you are correct that Haitians and Cameroonians both have temporary protected status. This administration has had a very strong record on temporary protected status designations, has had more designations than any prior administration, protecting more individuals from removal through those designations. I would say virtually all of the 16 designations currently have removals happening to those countries. That includes Haiti and Cameroon, but many other countries. It is a function and a feature, perhaps a flaw, of the statutory authority that we have been given for temporary protected status designations, that it only protects the individuals who are already here and eligible for those designations, but not individuals who are not eligible for temporary protected status. So removals are permitted. We assess carefully what individuals may face, either on an individual basis through the claims they make for protection or in the safety of those return flights. I think I'll end my remarks there, but happy to talk further.
And just a request before we start, if people could try to keep their questions tight, because I know we want to get a few more in today. Thanks so much.
Great. Hi, everyone. I'm Sia Hegde. I'm a civil and human rights lawyer from the National Homelessness Law Center based in New York. So in late 2022, the Biden administration issued a federal proposal to end homelessness, which raised a number of favorable benchmarks and commitments to combat the homelessness and housing crisis. It certainly is a good start, so I do want to acknowledge that. And our organization among many others, submitted comments to the U.S. Interagency Council on Homelessness for consideration in their public notice and comment specific to the implementation phase of this proposal. But the reality is that the United States, we're facing the largest, affordable housing crisis since the Great Depression, and housing is just not recognized as a human right. The unhoused are also, severely criminalized. We've heard this in multiple testimonies across the last several weeks of briefings. And, that is in direct violation of not just the ICCPR, but our own federal constitution. We are seeing a proliferation of tent cities and encampment raids in cities and towns across the country, the rise of involuntary civil commitment statutes and laws against unhoused persons, specifically with mental disabilities, and most concerningly, heightened incidents of police violence against unhoused persons that are triggered largely by racial profiling, xenophobia, and a complete lack of acknowledgement of the dignity and worth of those who are suffering in conditions of poverty. We are concerned about the federal government's budgetary priorities. I don't believe the Department of Treasury is here, but this question really would go to anyone who can answer. But we are concerned with the budgetary priorities, especially as it concerns gaps in critical social services, public education, compassionate mental health treatment, housing vouchers, any permanent pathway to adequate housing. So what steps is the federal government taking or will ensure to take going into the next fiscal year to ensure that funds are diverted explicitly from police budgeting and towards solutions that address the root causes of systemic homelessness and poverty? And what oversight, more so, is there over states and municipalities that are also diverting funds in this really dangerous and harmful way? Thank you.
Thank you for that very robust set of comments and questions.
Introduce yourself for that.
I'm sorry.
You did last time.
Dimitri McCain from HUD, Office of Fair Housing and Equal Opportunity, but also speaking on behalf of my colleagues who are in other parts of HUD as well. So this issue of homelessness is critical. We all know since the pandemic, we already had a homelessness issue before the pandemic, and it only got bigger and greater. And who suffers more is really along the lines of color in this particular country, right? Black people, brown people, that is clear. Regarding your question regarding the budget, the president's budget, we all are sitting here waiting for the next budget decision to come out. The president's budget prioritizes housing. I promise you it prioritizes housing. And we are already working towards the fiscal 25 budget as we sit here, even though we don't have a fiscal 24 budget yet. And I just want to make clear, but there's been reference earlier to the president's executive order regarding racial equity, but there was a second one that came out the beginning of the year. And in that second one, it says you must prioritize funding for the civil rights offices of the domestic agencies that we have. And I say that because we know that issues of homelessness, as I mentioned, fall greatly along color lines. So that's imperative. But there's also a big push, and my colleague from the DPC, Domestic Policy Council, may want to speak to this. There's also a big push on issues of housing supply. Right? There's a housing supply issue that we have, and where that housing supply issue exists, that puts the pressure on the market, right? And so we're trying to deal with those types of issues. A little earlier today, I talked about the incentives that we provide our community continuums of care to make sure that they're trying to look at issues that deals with homelessness in a way that doesn't criminalize it, right? And the guidance that we've issued in order to not criminalize homelessness types of issues. And so this is a huge issue. Secretary Fudge takes it as a big issue. The president takes it as a big issue. And we are certainly hoping for a robust budget. We have created, actually in the past budget, we've issued more housing vouchers. We have had funding for more housing vouchers than we had in the past. It's not enough. Let's be honest. It's not enough. So I'll pass the mic at this moment.
I think you covered that well, and in the interest of time, I think we should move on unless one of the...
I would say, we could talk offline, but on the criminalization piece, I'm happy to talk with you about the steps we're taking at the Department of Justice, both to be responsive to law enforcement agencies at the state and local level that, for example, we have an investigation to the city of Phoenix for how they've been treating homeless populations there, and also how we are working to work with our funding agencies that provide billions of dollars to law enforcement to be responsive through those channels as well.
want to comment. I mean, New York City has a current budget proposed for 2024 of over $11 billion for the NYPD, which is the largest police budget in the country. And social services have been, the funding away from Department of Homeless Service interventions has dropped, in a catastrophic way that is creating complete havoc. So I just want to name that as one example to, highlight the growing trend of what honestly there needs to be a solution and direct, response to.
Mayor of the city of Montgomery, Alabama. Let me speak to this. The federal government can do whatever they want. The solutions are going to come at the local level. So I welcome, your solutions at the homeless conversation we'll have in Los Angeles, November the 8th and 9th, again with Mayor of Los Angeles, Karen Bass, who's the chair of the U.S. Conference of Mayors Homeless Task Force, or Committee on Homelessness, as well as National League of Cities. We'll be meeting November 15th through the 18th in Atlanta, Georgia. I think what you're speaking to is going to be, we're going to need partnership at the city level and at the local level to assist us, even with the budget, even with some of the incentives that are coming from the federal government. These are things that have to be handled city by city. And there's not a mayor that I speak to, regardless of party, at the big city level, mid-sized city, small city level, one who has an issue with this, that's not looking for a great solution. So I think we're all looking for partnerships and collaborations on this issue. And I think for you and your colleagues, that will be helpful for all of us.
I know, we got to hurry up. I just want to say this, on the city-by-city solution, we do know that some cities have opted for the criminalization approach. There will be a reckoning soon. The U.S. Supreme Court has granted cert to a case coming out of the Ninth Circuit, I believe it's Idaho. But City of Las Vegas and the City of Henderson in the Las Vegas area have both likewise passed ordinances that some would say criminalize homelessness. We will find out shortly. My Attorney General's office has not supported those laws, and in fact has filed amicus briefs on the other side of this issue. So we're looking forward to a solution as well.
Hello, my name is Lily Eiler, and I'm with St. Louis University School of Law. Our shadow report focused on the city jail, where there is excessive use of chemical weapons, retaliatory water shutoffs, and also unreasonable solitary confinement. There are rules and regulations, internal rules and regulations in place to prevent these. However, they are being ignored. So my question is, based off of the reforms mentioned previously today and any future reforms, what commitment can you all make to compliance of these reforms?
Sure. So, as I mentioned before, the conditions in our nation's jails and prisons are and I think one of the real challenges that we see in some of the broader kind of criminal justice reform conversations is that, unlike policing, which oftentimes takes place on our streets and through body cameras, we don't see what happens in our jails and prisons, and no one knows as the gentleman said earlier, the extent of the abusive and really just unhuman conditions of these facilities. We in the Civil Rights Division recently opened an investigation to the Fulton County, Georgia jail, where there are literally individuals who are sleeping on the floor in animal feces. And literally this has gone on for months and years, and no one has said anything about this. And so within the Civil Rights Division, we have put a real focus and premium, a priority on our kind of jail and prisons work. We have opened a number of investigations. I mentioned Fulton County. We have investigations into jails in New Jersey, in California, and places around the country. We've also focused a lot on southern jails, not because there are problems elsewhere in the country, but we know particularly in the South, based on complaints we've received and other information, that conditions are particularly challenging there. So again, in the interest of time, I'll stop there. But if there are other facilities that you think are worthy of investigation, we'd love to hear from you.
Yes, hi, good afternoon. I'd like to drill down a little bit more on this homelessness criminalization issue, because it has not only racial implications, but racist implications as well. So I'm David Peary. I'm the executive director of the Miami Coalition to Advance Racial Equity, and we advocate on behalf of the unsheltered people who are condemned by poverty to sleep on the city streets. And I phrase it that way because homelessness ultimately is not a personal choice issue, an issue of making bad personal choices, but is an issue of that needs to be addressed through systemic reform. I noticed that someone earlier started their answer to this criminalization issue by citing the advances that they're making in mental health and in substance abuse rehab. That is absolutely wrong. Okay, it's not mental illness that drives homelessness. Only about 25% of the homeless population suffers from severe and persistent mental illness, which means that 75% either have manageable conditions or do not have any mental issues. Substance abuse does not drive homelessness. Okay, in fact, homelessness is more likely to cause substance abuse. It's so intensely traumatizing, painful, you're suffering on the streets, and you self-medicate. If you didn't have a drug problem before you became homeless, you certainly are going to have some type of problem after you become homeless, okay? So we need to disabuse ourselves of this notion here that somehow bad personal choices lead to homelessness, because what that does is inappropriately takes the focus off the system that manufactures poverty and breeds homelessness, okay? So, and that is the predicate to the criminal justice system. No one intends to be homeless. For all the years that I have been that I was on the streets and all the years I've acted as an advocate, I haven't met a single person who freely chose to be homeless, who would refuse permanent housing. People are homeless not because of choice. People are homeless because they lack choices, because of these systemic issues that drive it. No, and I'll give you one example of a systemic issue. Nowhere in the United States can you work full-time at minimum wage and afford a one-bedroom apartment. Nowhere. Okay, that's one systemic issue. With the federal government, the federal minimum wage is stuck at what, $7-something an hour for the last 2 decades. Okay, so let me get into my point here. It is very important to look at this through a racial equity lens. Okay, African Americans are only 13% of the population, yet they're about 40% of the homeless population. In Miami, it's even worse. 18% of Miami-Dade County is Black, but 60% of the homeless are Black. So Black people are not 3 times more likely to be mentally ill, drug addicts, or irresponsible, lazy bums. Okay, you must look at the systemic issues such as endemic intergenerational poverty and historical systemic racism. These are the drivers of homelessness. And so what our communities are doing now are inappropriately using the police and the criminal justice system to not only blame the victim, but to unleash the police and attack the poor instead of attacking poverty. So my question is, and by the way, the federal government is also complicit in this. Just a few months ago, the U.S. Park Police raided McPherson Square and cleared an encampment. Okay, and so you unleash the federal police powers then to do the very thing that the folks on this panel here are condemning. So you can't just blame the cities, all right? The federal government has also been complicit in this. So my question here is, what are you going to do to stop this inappropriate blaming the victims of poverty and attacking the poor instead of attacking poverty itself? How are you going to prevent or tell the cities or have some type of penalties for cities that inappropriately unleash the police on the homeless?
Thanks, sir.
So I'll just start at the criminalization piece, and I don't know if my colleagues at HUD want to speak more. So yes, you're right. I mean, I think we see the overuse and misuse of law enforcement in an array of contexts. And I think that what you just described in the context of homelessness is, unfortunately just one of, I think, a number of situations. As I mentioned, in the Civil Rights Division at the Department of Justice, what we could do through our enforcement authorities is bring investigations against law enforcement agencies that are violating federal or constitutional rights. We've done that in the context of what you're calling the criminalization of poverty, as I mentioned, in the city of Phoenix, where we've seen particularly egregious examples. Again, if there are other municipalities that you believe warrant investigation, please let me know. I will say to this issue and to kind of every issue, we're not going to solve these problems through enforcement. We don't have enough lawyers to bring lawsuits against every police department, against every municipality. And so part of what we're also trying to do is think about how can we use our other levers of authority to be responsive to this concern? How can we come up with, use the litigations we bring as an example, as to try to create kind of promising practices that could be encouraged. We also are working with our funding agencies. As I mentioned before, I know we give billions of dollars every year to these law enforcement agencies, and we are working to provide additional guidance and training to make sure that they are not using those funds in ways that risk or violate federal rights. The one thing I would say, two other things I would say in response to that, I'll stop and we can talk more later. First, on the issue of how do we stop homelessness, we also know, in addition to the really valid points you raised, that we have to stop the pipeline of homelessness. And so one of the things that Attorney General Garland really focused on, particularly during the COVID pandemic, when we saw obviously a rash of evictions, is how we can mobilize the legal profession more effectively to make sure that we are assisting people, providing them lawyers so that they don't get evicted and don't kind of enter the cycle to begin with. The second and last point I'll make is that, and again, picking up on the point you made, that this really is a part of a broader conversation about the criminalization of poverty. And again, that's a place where we see concerns happening across a range of areas. And just a few months ago, the department, we re-released guidance about the use of fines and fees and other similar measures by state and local court systems, which we know, again, similar to the eviction issue, helps kind of, lead to the cycle of people being kind of unable to pay fines, going to jail, unable to work, and so on and so forth. And so, yes, this is a big problem. It's a big challenge. And again, happy to talk more about that.
Glad you mentioned systemic issues. Secretary Fudge made it clear that the biggest growing population of people homeless are African-American women over the age of 60. And that has nothing to do with mental health types of issues. But a priority, I will say, on our regulatory agenda is also the issue of unnecessary barriers based on criminal records that keep people out of housing. That is a priority on our agenda, regulatory agenda right now. And I'm going to pass to my colleague who can say a little bit more about another systemic issue.
Thank you. Very quickly, Lynn Grasso. I am the Deputy Assistant Secretary in the Office of Fair Housing at HUD. We have the authority to enforce the Fair Housing Act, and we also have authorities under Title VI and 504, and we use those authorities to fight policies in communities that are designed to exclude people from housing that have criminal backgrounds and exclude people from housing that require emergency services to be safe. And we are pursuing these policies aggressively. We know that these policies are often targeted to Black and Brown communities. They are disproportionately targeted to poor Black and Brown communities. So these are civil rights enforcement authorities that we are exercising. You can read about one particular action we took against the city of Hemet and other actions as well. But we intend to use those civil rights authorities to ensure that people are not excluded from housing and that discrimination and racism does not fuel homelessness. Thank you.
We can talk later about details about that case.
Thank you.
We're only going to have time for a couple more questions in our formal session, but do just want to remind folks that we will have time afterwards. So please go ahead.
Ambassador, my sister, we talked about the U.S. Maternal Health Department. I want a U.S. Maternal Health Department. I got doulas, I got repro justice, I got midwives from Hawaii. I've got the ERA, passing the ERA. So I'm going to ask you, I need an appointment with you so we can sit down and we can start working on this for real. Okay? Y'all ain't got to talk. Ambassador, truth and reconciliation. We'll talk about it. Now there's a crisis, and I don't know if you guys are aware of it, but there's a crisis of orphan children, of mothers who have passed with HIV and COVID, and I need you all to address that crisis and not address it by putting children in foster care, but it needs to be addressed, and it is a crisis, and we need to handle that. We need to abolish slavery in the United States. I want the 13th Amendment clause that creates slavery and this mass slavery system that's called mass incarceration. I want that gone. So I want that clause in the 13th Amendment that allows slavery, if you're convicted, gone. I want a free America with no slavery. You deal with how you're going to deal with that. And I want the investigations based on our shadow report, Blood at the Roots. I want the investigations of Billie Holiday's death, along with COINTELPRO and all the other deaths. And I want Assata Shakur to be able to come home and be comfortable at home and not have to worry about police officers in New Jersey killing her. So that's all I got to say. Y'all ain't got to say nothing. I'll see y'all later.
Thank you for always speaking so passionately.
Good afternoon. I'm Traditional Chief Gary Harrison from Chicxulub, Alaska. And a couple of things. First of all, I'd like to ask the Justice Department to ensure that we get our COPS grant. I know you talked about it earlier. And whenever we have COPS, they have to get a grant. And if we don't get it, they're gone and have to start over. And from Department of Interior, hello Heidi, good to see you again. We'd like to see about having you guys have the Department of Bureau of Indian Affairs have some of our COPS money in there too. I know that you make the excuse that there's no Indian country, but we do have jurisdiction. That's one of the most recent things that have come around. So you can put money into the state of Alaska and our COPS program. And for the Department of Education and for all of the rest of you, in 1824, Russia tried to claim sovereignty over Alaska. The United States and Great Britain both immediately said no. When you signed the Treaty of Cession in 18 whatever, there was a clause in the end that says that they're only selling to the United States what interest they had, which is a quitclaim deed. And Seward asked the Russians, what did we sell? They got the answer from the Kuznetsov memorandum that said they didn't sell them Alaska. They sold them 2 forts on 2 islands. So I argued with Justice Department, or not a Justice, but university, and they said, you're right. They just assumed jurisdiction, which when I looked it up in the Department of Law, it says without law. So that's how you guys took over Alaska, my country. That's part of it. And the other part is that in the 30s, they brought in the colonists to the community where I live. And so I know all about colonization, and we need decolonization because you never decolonized Alaska according to the UN Charter, which you guys helped, you guys being the United States, helped write and have ratified. And the reason that we're here under this is because you've also signed and ratified the ICCPR. And then it has self-determination. And when they voted for statehood, there was a clause in there that said that, or not a clause, but there was a law in the books that said that if you're a native, you have to prove that you can read and write English and have 5 white people sign that you're competent. So how many natives actually voted for statehood? Not many. Who voted for statehood was the colonists, the merchants, the miners, the military, and other ne'er-do-wells like politicians. So Alaska was never decolonized like it was supposed to have been. So I want to know about how you're going to take care of the problem of decolonization that has never been taken care of in the state of Alaska.
Thanks, sir. For 2 minutes.
Yeah, I understand that you're giving me 2 minutes and you're giving them a whole bunch. And the other thing I wanted to say is I see you're planning a big party out here, and we didn't come here to party. We came here to talk to you about our issues.
Halfway across the world for this. My name's Heidi Totticini. I'm a senior advisor to Secretary Holland at the Department of the Interior, and I just want to take a moment to address Chief Harrison and thank you for being here today. As you know, the Department of the United States is working hard to uplift tribal governance and our nation-to-nation relationship with tribes. I can speak to you more in depth about some of these issues if you would like after this program and once we decide what direction that we're going in. But to just address very quickly the last comment that you brought up, I would like you to know that in our last budget for the FY24 presidential request that we've been working with OMB for tribal communities, the BIA did put in a budget request that's $64 million over the FY23 request for specifically public safety and justice issues, and of course, missing and murdered Indigenous peoples issues as well. That includes Alaska. And so just know that I know you specifically referenced the STOP program. And again, we can speak a little bit more to that. Especially as the budget continues to move forward and it's closer to its preliminary stages for FY24. So I just wanted to mention that. And again, thank you for being here and happy to connect with you after this.
I think we're checking on what our facilities capabilities are, but we can take the next question.
Greetings, my name is Ahmed Abu Znaid with the U.S. Campaign for Palestinian Rights. There is a dire, unprecedented humanitarian crisis unfolding in Gaza, and there is mounting evidence that the U.S. is complicit in genocide. The Genocide Convention prohibits complicity in genocide and imposes a duty on the U.S. to prevent it. The U.S. is clearly failing its obligation. There is unambiguous evidence that Israel is committing the crime of genocide against Palestinians in Gaza. Since October 7th, Israel has carried out indiscriminate bombing campaign against 2.2 million Palestinians living there, while cutting off all basic necessities to the population: food, water, electricity, and medical supplies. It has used white phosphorus bombs in Gaza, which are by design weapons of indiscriminate nature. On October 13th, it warned 1.1 million people living in the northern part of Gaza to evacuate to the south within 24 hours. As people fled, Israel bombed them. A UN expert said, quote, Israel has already carried out mass ethnic cleansing of Palestinians under the fog of war, end quote. Israel has revealed its genocidal intent through statements by top government officials, and it has acted upon them. And with full knowledge of this, the U.S. has doubled down in its support of genocide by pledging additional military aid, diplomatic, and political backing. Just yesterday, you heard the story of Wadi al-Fayoum, a 6-year-old Palestinian Muslim boy stabbed to death. His mother was also stabbed at least 12 times. The murderer was motivated by the genocide in Gaza and repeated, "You Muslims must die," while he murdered the young boy. The U.S. must take this opportunity to address the international community and reassert its commitment to the right to life. The U.S. must cease its support of a regime that is committing genocide of the Palestinian people. If we don't act now, then the words "never again" will be just that, words. So my question to you all, and maybe you'll have to talk to the president, will the United States government stop providing military aid as well as political and diplomatic support to the state of Israel, which is committing war crimes and crimes against humanity, including genocide?
Well, certainly the events of the past several days have been something that we've all been consumed with, I would say diplomatically. Also, I'm here at the United Nations. President Biden has spoken in recent days, including references to the importance of the security of civilian populations. We condemn the violence. We condemn certainly the horrific terrorist incident that happened in Israel. I will defer to what our president has said, my Secretary of State, who I understand is in the region today, Secretary of Defense, and what I can say is that this is a top priority for the United States government. I don't know if Ambassador Taylor has more to add to this.
I think it's probably best to just not respond then. Thank you.
you.
I also want to note on that point that when the federal government conflates Jews with the state of Israel, it puts me at risk. I am a Jew in solidarity with Palestinians everywhere, and I don't like to be considered part of the Zionist community. I am not, and you make my life less safe when you pretend as if all Jews are represented in this atrocity. So wanted to make that mention. I also want to say that everybody here today is talking about the same thing, which is about power. And right now in the United States, power is concentrated in the hands of very few, while more and more of us are suffering. And that is, at the end of the day, why we're here. We do not, Ms. McCain, have a shortage of housing. We do not. We have, number one, a shortage of affordable housing. We have vacant houses everywhere. What we have, we do not have a homelessness crisis. We have a priority crisis. And I have to say that your answer about we're putting money in the budget for more housing, you said for vouchers. That's a problem. Vouchers are not working. Landlords will not accept them. And there are so few available. But if every housing authority in the entire country were to fix up their vacant houses and put homeless people in them, we would decrease the number of homelessness overnight by 10%. 10% just by putting people in the houses that are owned by the housing authorities of this country. So we have a priority crisis part of it is having to do with HMIS. I'm Stephanie Senna. I'm the Anti-Poverty Fellow at Villanova University, and I also run a homeless shelter. I get funding from HUD. The shelter's called Breaking Bread Community. We spend the vast majority of our energy and resources dealing with HMIS, which is a terrible system that's meant to means test people. All service providers can't stand it. Most really good providers won't even provide for the government because they don't want to have to deal with HMIS. We do not, HMIS, which demands that we make sense of chronic homelessness. I also want to make sure that we're clear. We don't have chronic homelessness, we have chronic unaffordability. And when we focus on chronic homelessness, we're focusing again on the individual as opposed to what the systems are. The systems that say 1 out of 7 homes in the United States right now is owned by an equity firm. Blackstone primarily, and in some cities, it's 1 out of 4 houses that are owned by equity firms. So we have a massive problem in this country, and it's a priority issue. We need to make housing a right. We need to uphold the ICCPR, and we need to make sure that people have the resources that they need to thrive. Right now, they don't. Mr. Manuel came up here and he talked about the country being considered a third world country by other countries. I want to say, before I came to Switzerland, I was in Scotland, and I was traveling through Scotland, meeting with people who are activists. There is no homelessness in Scotland. There is no homelessness because they have human rights for people in Scotland. And they have dedicated a system to that. And they're horrified to hear of what we're doing over here in the United States, how we have so much homelessness and criminalization in the United States. And I also traveled through Palestine. They don't have homelessness in the West Bank either. They have lack of resources, lack of water in the West Bank. Their resources are being stolen, but they do not have homelessness because they care for each other and they make that a priority. You travel most of the world, they don't have what we have in the United States. So what I want to know is, how will you actually make housing a priority? How will you actually stop helping people who are already in power get more resources and more power as more and more of us are struggling to survive? Thank you.
And I certainly do. And I certainly do agree with you. We at HUD, as you know, all we deal with are people who are low income and moderate income. So when I say there's a housing supply problem, I'm talking about affordable housing supply problem, right? People who are we all know the Out of Reach report. We all read that every single year. There was reference earlier regarding the minimum wage, how it doesn't, meet housing needs. So absolutely, that was in reference to a lack of affordable housing. Absolutely. When I speak of the vouchers, clearly source of income discrimination is real. It's very real. For folks who don't understand, that means that landlords in many places where there's not a jurisdiction, there's not a city, and if the city or the state does not have a source of income protection law, then that's an issue. right? And so we're looking at that. We also, our FHA at HUD is definitely all over this issue of investors buying up houses. That is a critical issue. It is a priority where we are. But we are not going to simply fund just public housing because we know there's a lot that's needed there, but do both. We're doing more than one thing. And I certainly urge you on behalf of Secretary Fudge to push for whatever budget levers possibly that you have so that we can get the requests we've made in our budget. And if we can get more, that'd be even better. So I'm happy to talk to you later on after, but I'm glad you're one of our COCs.
I appreciate that. And just one other thing is that the
really
HUD
need
grant
to-
was for $1 million.
I really need to move on because we have other people who want to speak.
Okay,
I'm sorry.
just the money is being mismanaged where it is. Thank you.
So I think
Thank you
what
for
I'd
your
like
answer,
to
Ms.
do,
McCain. I
because
appreciate it.
I am being told that we wrap things up, but what I'd like to do is the folks that are still standing, I'd like to hear from all of you. And then if we have time, we can respond to what you're asking here. If we don't have time to respond in the room, then we can respond when we're all gathering together. Okay.
Hey, I will be brief. My name is Dr. Elisa Warren. I'm president of the International Association of Official Human Rights Agencies. We are an association of human rights agencies serving nearly 250 million people in the United States. We joined with many other civil society organizations in support of the U.S. NHRI. And we're really concerned at the lack of progress since the August 2022 surge review. Very concerned, in fact. Our IORA members work closely with our federal partners every year on the ground. We are the people doing the work in the communities, and we're concerned about the lack of progress. We're working hard to implement human rights enforcement, human rights education, and we need to know that you need to know that it's just not enough. There's so much more. There's more resources that need to be brought to bear, more focus on the issue of human rights. You can hear what my colleagues here are telling you. The needs are critical, and we need to know from you, I guess, Sir Justin Vail, when can we expect at the very least, a study, a study on the administration, from the administration on a United States NHRI? When can we expect that?
Thank you so much again for raising this issue. Again, we are considering all recommendations on how we can improve our domestic implementation of our commitments under international law and obligations, including the National Human Rights Institute. We have no other information to share with you at this time. We'll continue this conversation with you. Thank you.
Thank you very much. Aneptu Waste, good afternoon. My name is Stephanie Amiot. I'm an enrolled member of the Ogallala Lakota tribe, and I am also the legal director of the ACLU of South Dakota, North Dakota, and Wyoming. The Black Hills of South Dakota, which were illegally taken in violation of the Constitution and treaties, continues to have significant increased mining claims from 2022 to 2023. In fact, over 70,000 claims were granted from April of 2022 to the present date, and well over 200,000 mining claims presently exist in the Black Hills. This is allowed by the National Forest Service, despite its known designation by the Sioux Nation tribes as a sacred indigenous area and in need of protection as a cultural and spiritual site that is essential to the future well-being and existence of Sioux Nation peoples. The Black Hills and its rivers and lands are a source of drinking water, cultural, and spiritual significance as protected by the First Amendment, the Supremacy Clause, RFRA, and other federal legislation protecting indigenous religions. However, the damage to the Sioux Nation's ancestral lands and waters is still significant, and it's ongoing, with harmful levels of arsenic above EPA recommended levels in at least 25% of the well waters tested in indigenous communities in South Dakota. Exposures to elevated levels of arsenic in groundwater contribute to significantly increased likelihood of heart attacks, diabetes, strokes, and other deadly diseases. Lakota peoples in particular have the highest death rate of any group in the United States. Lakota youth have suicide rates 150% higher than any other youth group in our nation. and Indigenous peoples already suffer more negative health outcomes than any other population. But yet, Congress only funds IHS at 48%, leaving 52% of Indigenous peoples without adequate mental and physical health care. Against this backdrop, first, what is the United States doing to protect the sacred Black Hills, besides limited withdrawal recommendations in piecemeal fashion like the Pactola watershed for only 20 years, to protect the future existence of the Sioux Nation people when mining threatens drinking water supplies and interferes with cultural and religious practices? Second, as a show of reconciliation between the United States and the Sioux Nation tribes, will President Biden and the Department of the Interior officially declare and recognize the Black Hills in their entirety as a sacred Indigenous area, as Sioux Nation ancestral lands, and withdraw them within their entirety from all future mining claims? We urge both to allow the United States to fulfill its obligation to protect the future existence of the Sioux Nation tribes. Thank you very much.
Good evening. My name is Monet Holder. I'm the Senior Director of Advocacy and Programs at Florida Rising. So following the Shelby v. Holder decision in 2013, which resulted in the removal of preclearance protection as it relates to the passage of voting laws that have proven to overwhelmingly suppress the vote of predominantly Black and Brown people across the country, and specifically in the South, we have seen waves of legislation passed that not only restricts access to the ballot box, but also allows the drawing of gerrymandered maps that diminishes Black representation. Organizations like Florida Rising and community members have resulted to using litigation to regain our fundamental right to vote. However, as you know, that process is tedious and costly. Sometimes we win, but sometimes the court does not always rule on the side of democracy. There are several remedies on the table, such as Congress passing the John Lewis Voting Rights Advancement Act, which would restore preclearance protections and other protections to the VRA, as well as the Freedom to Vote Act, which will set national voting standards for voters and voting rights laws, including the redistricting process. Another remedy is to institute independent, nonpartisan redistricting commissions responsible for creating new maps in the redistricting process. With all of those remedies on the table, we still find ourselves at a detrimental standstill. So my question to you all is, how and when will the disenfranchisement of voters of color be prioritized and addressed? Thank you.
Ayayanchu. My name is Natalie Segovia, and I'm the Executive Director and Senior Attorney at the Water Protector Legal Collective, a legal nonprofit organization that began in response to the mass criminalization of water protectors, those that were protecting the water in opposition to the Dakota Access Pipeline. While the rights of Indigenous peoples are routinely violated, and there are countless issues I could ask you to address, both under US and international law, I want to address here the issue of incarceration generally, and specifically of Indigenous peoples who are disproportionately impacted by incarceration and underrepresented in the statistics around this. This is to the DOJ. Ms. Tessier and Mr. Smith, in response to the comments by Mr. Ian Manuel, you read from prepared notes and indicated that federal prisons under the BOP are under the jurisdiction of the DOJ. You indicated that solitary confinement is to be used with restrictions and in a humane way. You used the term housing. Incarceration is not housing by any means imaginable. Solitary confinement in a cell barely larger than an elevator or parking slot and lockdowns are not humane. It is offensive to all of those here, to Mr. Manuel and other directly impacted Black relatives that also spoke today on these issues and death by incarceration, that you need to rely on canned responses to address questions from unique human experience. Remember your humanity. When you speak with people who are not sharing a story, they are sharing personal lived trauma. Currently, the longest serving US political prisoner is Leonard Peltier. He is an Indigenous elder who has spent over 48 years in federal prison for supposedly shooting 2 FBI agents on a sentence amounting to death by incarceration. The prosecutor who helped put him in prison has asked for clemency, along with many others, and stated his imprisonment was a result of racial bias and discrimination. Despite his innocence, he remains in prison, and President Biden has not addressed his clemency petition publicly. In addition, the Coleman USP federal prison is constantly in lockdown. As one of Mr. Peltier's many attorneys, I can attest personally that the prison is regularly on lockdown, and Mr. Peltier is regularly in solitary confinement. I went nearly 3 months without reaching Mr. Peltier, even by phone, during the lockdowns instituted at Coleman. Lockdowns and solitary confinement described as alternative housing is unacceptable and not humane in any possible imaginable way. The demand is this: the DOJ needs to do better. The questions I have are this: what will the DOJ concretely do to address the use of solitary confinement as cruel and unusual punishment? What will the DOJ commit to do to expedite the resolution of the case of Mr. Peltier, who remains in prison as a political prisoner for over 48 years? What will the DOJ do to look into the rampant issues at USP Coleman and federal penitentiaries around the United States? If you're unfamiliar with the case of Mr. Peltier, Dr. Michael Koch here of the ad hoc Leonard Peltier Defense Committee, whom I just met today, has some postcards that can provide to all of you seated here today. And finally, generally, to all of you here, how is the United States fulfilling the mandates of US law, let alone the ICCPR, regarding Indigenous peoples? Thank you.
Hi, I'm Jennifer Aisha Loveland Rose. I'm here from the Program for Human Rights in the Global Economy, and on behalf of Food and Water Watch and the community of Jackson, Mississippi. The United States has refused to recognize the human right to life and its component right to water. Yet currently, low-income communities of color in the United States are frequently unable to access clean and affordable drinking water due to historic and continuing disinvestment in their water systems. This is an embodiment of environmental racism, diverting funding away from Black, Brown, and Indigenous communities in favor of their whiter and more affluent counterparts. We believe that data transparency is foundational to guaranteeing their right to safe and accessible drinking water for all without discrimination. When will the EPA restart its community water system surveys and commence the needs assessment for nationwide, rural, and urban, low-income community water assistance authorized in the Infrastructure Investment and Jobs Act? That's for Kareem Marshall. Thank you. Will the EPA commit to including data on affordability, shut-off prevalence, and discrimination and civil rights violations with specific attention to Black, Brown, and Indigenous populations, and record that data by census tract when conducting the collection? Will the EPA propose a rule requiring transparency in state disbursement of funding received predicated on high-need data from Black, Brown, and Indigenous communities without their aging water systems? And finally, will the DOJ commit to holding state-level decision-makers accountable for diverting funding away from predominantly Black, Brown, and Indigenous communities? Thank you.
Thank you. My topic gonna be immigration and customs enforcement, data-driven enforcement. I'm Hinako Sugiyama. I came here from UC Irvine School of Law, International Justice Clinic directed by Professor David Kay. As far as civil society and academia revealed, ICE now covertly obtaining bulk access to information from myriad of data sources, including private data brokers and tech companies, social media monitoring tools, automated license plate readers, facial recognition system, even foreign law enforcement agencies where without any rule of law, in order to arrest, deport, and silence people. And this data is then consolidated into database and applied automated analytical tools. And it reveals people's location, activities, and traits. And immigrants who spent years in the United States are subject to sudden arrest and deportation just because they obtained a driver's license or getting access to essential services, like utility services. And also it causes chilling effect, including exercise of freedom of expression, especially marginalized communities whose voice to be heard. So applying the jurisprudence at the Human Rights Committee, simply applying these rules to these facts, we got to the conclusion that this practice violates Article 17 and 19. So my question is how the United States, what step the United States will take to ensure that ICE data practice comply with ICCPR. And 6 months ago, I posted the same question to the civil society consultation, and the person kindly answered at ICE, kindly answered to me that we comply with the law. But today we are talking about that, not that US domestic law, but talking about ICCPR. So I would like to hear from your view, especially. Thank you.
Good afternoon. My name is Manjusha Kulkarni, and I'm Executive Director of AAPI Equity Alliance and co-founder of Stop AAPI Hate, the nation's leading aggregator of anti-Asian hate incidents. Since March 2020, we have received over 11,000 direct reports from all 50 states, which include verbal harassment, discrimination in housing, retail, and the workplace, and in some cases, physical attacks. The vast majority, however, are not hate crimes. But this number, 11,000, represents only the tip of the iceberg, as Pew Research Center, AAPI data, and University of Chicago have found that up to 45% or 10 million Asian Americans have experienced discrimination in the past few years. Beyond countering interpersonal hate and racism, we're currently confronting the alarming surge in anti-Asian scapegoating within American politics and policymaking. Following Florida's recent enactment of an alien land law, 33 states have proposed land bans which prevent Chinese immigrants from purchasing and in some cases even renting property simply because of their national origin. Given the fact that most incidents of anti-Asian hate are not crimes, what actions are DOJ taking to collect key data related to civil rights enforcement? What efforts is it taking to review and challenge the unconstitutional land bans? And finally, we want to know, given that we have learned in the last 24 hours that the FBI is visiting mosques across the country, what is the Biden administration doing to avoid the racial profiling and surveillance that the previous administrations took against South Asian, Muslim, and Sikh communities in the backlash of 9/11?
Good afternoon. I want to thank you all for being here and hearing our concerns. My name is Hannah Gary, and I'm a professor of human rights law at UCLA Law School. I head up the Promise Institute for Human Rights. And my comments and questions want to circle back to one that was raised earlier, and it has to do with what plans does the U.S. government have to take concrete steps towards the right to an effective remedy for torture and prolonged arbitrary detention for all individuals that have been subjected to our enhanced interrogation program. I am among a group of attorneys that represent one of the longest held detainees of that torture program, Mr. Abu Zubaydah. He has now been detained for 21.5 years without charge, and he was among the first subjected to our torture program. He was a test case, and the brutal techniques that were subsequently used on over 100 individuals after him were used, including confinement in a small box, waterboarding over 80 times, isolation for 47 days, sensory manipulation, sleep deprivation, sexual violence. Abu Zubaydah was transferred to multiple Black sites in various countries. So what I ask of you is, first of all, what steps will the Biden administration take to work with those countries that are implicated in the extraordinary rendition program and release Abu Zubaydah and other detainees to destinations where their rights can be protected and they can be rehabilitated in accordance with the right to an effective remedy? Second, will the U.S. government officially acknowledge its post 9/11 enhanced interrogation program as torture, as now has been noted by several U.S. Supreme Court justices and federal courts in the United States, as well as Congress? And third, will the U.S. government apologize for using my tax money for torture and prolonged arbitrary detention of individuals subjected to its enhanced interrogation program? And please tell me what other measures you're going to take to provide truth, reparations, and guarantees that this will never happen again with my money.
My name is Denise Labertu with Women Lead Network, and I was very excited to hear Mr. Smith from the DOJ talk about the prioritizing of prison and jails work, because I'm going to talk to you today a little bit about the experience of women who are incarcerated. So it's no secret, right, that the U.S. incarcerates more than 1.2 million people. This is a low estimate because it does not include things like juvenile and immigration and pretrial. And while only 10% of those are women, their carceral experience has increased by 700% over the last 4 decades. I want to sort of address with you 2 issues. There are a variety of them, but I'm going to keep it to 2. 2 issues that I think are important for you to think about as you're thinking about your prison and jails work. The first is recent disclosures from women prisoners and detainees, especially in California and Georgia, about the forced sterilization that they experienced at the hands of prison medical units. By the way, this in California happened while the state was under a receivership for problems with their medical services. California has implemented a reparations program that is ending in, I don't know, maybe 2 months. And less than 1% of the people who could apply for that have even applied for it because they don't know about it. So, one of the questions that I would ask you to consider is, how do we really think about oversight in relationship to things like informed consent, especially when it comes to people who are vulnerable and women in prison? The other issue that I want to talk about today is the relationship between gender-based violence and the criminalization of self-defense. So gender-based violence survivors are criminalized and arrested and prosecuted for a variety of crimes, including leaving home with their children, engaging in drugs or sex work that is criminalized, right? And also killing or fighting back against their abusers. And their sentences tend to be 3 to 4 times more significant than if their abuser had killed them. So one of the most effective strategies in actually addressing these issues is to provide supportive services for survivors of gender-based violence that are not linked to the criminal justice system. So many of the services that are available currently are linked directly to arrest policies or the Department of Justice. As a former TA provider for the Department of Justice, I happen to know this. So thank you, and I'm hoping you can address those.
Hi, can you hear me? Sounds like it's working. My name is Lorelei Lee, and I am a trafficking survivor, and I am also an independent sex worker of almost 2 decades. At age 37, I went to law school because I wanted to know why my friends were dying. I'm here today speaking on behalf of the Disabled Sex Workers Coalition and Sex Workers and Survivors United. We need you to know that sex workers and trafficking survivors are not discrete groups who are in opposition to each other. Our needs are the same. What we need is not more policing. We do not need traumatizing raids on our places where we work, and we do not need profiling on the streets. What we need is prevention. And I am so tired of the United States acting as though the criminal justice system is the answer to everything. It is useless to us to be offered civil penalties like fosta sesta that we can't access. I mean, you think that most trafficking survivors can provide their legal names in public and wait years for who knows what? Our traffickers don't have money. So guess what? Guess who gets sued? The hotels get sued. And then guess what happens? The hotels profile us and they exclude us. The internet platforms get criminally charged and they exclude us. They profile us and they exclude us. The banks, they
they close our accounts without any warning. They hold our money. And guess what happens after that? We have to rely on a third party to do everything, to get housing, to hold our money, to potentially get out of chronic poverty, which is almost impossible. One of our members right now needs $87 for blankets. She just barely got housed in a basement with her children. And I just think it is disgusting how little we need and how much this country has. I do need to say one more thing on behalf of the Disabled Sex Workers Coalition, which is that I have a rare genetic disorder. Some statistics say it is 1 in a million people. I know 4 people with this disorder, and all of them work in the sex trades because that is the only way that we can survive, because we don't have access to health care. So I'm going to echo everybody who has already spoken. We need housing, we need clean water, we need food, we need health care, we need basic resources. We do not need more policing.
Good afternoon, and thank you for this, I guess good evening, and thank you for this extended consultation. I'm Dr. Heisler. I'm a practicing physician and medical director at Physicians for Human Rights, and I'd like to turn to the question of reproductive justice and health and rights. By removing constitutional protections of the right to abortion, Dobbs unleashed the power of individual states to restrict, criminalize, and totally ban abortions. And unfortunately, many of the states that have criminalized abortions are those in which voting is most restricted and in which rates of maternal morbidity and mortality and disparities are the most severe. So actions at the federal level to date are commendable. Efforts to leverage EMTALA, the Emergency Act, efforts to preserve the authority of the FDA to approve medications. But my question for you now is, going forward, what are other ways the U.S. might or is working to uphold its treaty obligations at all levels of government to protect reproductive rights and safeguard medical professionals who are trying to meet the needs of their patients by providing abortion care. Specifically, what, if anything, is planned to help safeguard protections for providers in states that do respect the right to abortion, that are seeking to provide telemedicine, in those states that are trying to protect their providers by adopting shield laws? I don't know if there's anything that could be done at the federal level to further strengthen shield laws. But again, just was really eager to know, what are the different plans for protecting reproductive health and rights? Thank you.
Aloha mai kākou. My name is Ki'ina Neokalani ka ho'ohanohano, and I am here from Maui, Hawaii. Thank you for the opportunity to speak. I appreciate you extending the time. I am first and foremost Kanaka Maoli, someone who originates from the land of Hawaii. We're not Native Hawaiians. Just to be clear, we are Kanaka Maoli, often referred to as Native Hawaiians. Native Hawaiians are living in a very oppressive state, as we are still occupied as the Hawaiian Kingdom under the United States. I would like to bring up a question as to when, if any of you, plan to address the treaties that are not being acknowledged. Our people continue to be some of the highest disparities in all of the areas that we've discussed today. The list is so long, I'm not going to waste time. You know what the disparities are. We have been second-class citizens in our own home since the overthrow, houselessness, all the things, especially since the fires. I am a midwife who became a midwife first and foremost because I was a cultural practitioner of Lomi Lomi La'au Lapa'au, Ho'oponopono, all of our traditional practices, which were passed to me, thank God, by some of the last of my living elders. I am one of the only Native Hawaiian Kanaka Maoli practicing palikiki. And unfortunately, after decades of trying to come up with exemptions for terrible licensure laws, which restrict us now from practice as of 2019. When the law passed in 2019, there was supposed to be a 3-year time where there was what they called a birth attendant exemption, where we were promised through a task force recommendations. I sat on that task force. I was the traditional midwife. I went on my own dime to fly to Oahu, where this was held, with my brand new baby. And all of our suggestions have been completely ignored through the task force. And what was promised that in those 3 years after the law, for all practitioners to be incorporated into law as not to cause further cultural erasure of practice or pathways for my children to have the opportunity to birth the way we see fit as Kanaka, none of that has been incorporated. And so at this point, the 3 years has already expired. As of July 1st, 2023, I am currently illegal to even give advice to pregnant people. We have the highest disparities. Most folks think that it's African Americans because it has been until there was finally, just recently, a few months ago, new CDC information that shows you that Native Hawaiian women and Polynesian women have the highest disparities of maternal morbidity. 450% higher than white women. And 80% of those disparities, those deaths, were deemed preventable. I live in an area, Maui County, that is actually consisting of 3 islands. We have 1 hospital for those 3 islands. We have very limited access. Most of our areas are rural. We can't even get prenatal care. So you know what I've done for 20 plus years? I go to those rural areas and I give free prenatal care because I care about our people. And I want to be a part of the solution to these disparities.
Ma'am,
Now I can't do that. So I'd like to
Time.
know if you're going to look at the CERD report that we filed, if you're going to do something about it, or what? We need your help.
Thank you, ma'am.
Thank you, Kiki. Hi, everyone. My name is Bethany Van Kampen Saravia. I'm Senior Legal and Policy Advisor for IPASS. And my question is going to be a bit of a follow-up to my colleague, Dr. Michelle, regarding the Dobbs decision. And my question is about language and how we elevate and operationalize our commitment, not just to sexual reproductive health and rights, but to access to abortion as a human right. The U.S. is the largest bilateral donor to family planning and reproductive health in the world. Because of this, we have an oversized influence in this space globally, despite the fact that the U.S. is just one of 4 countries that has regressed on its laws globally in the past 20 years, whereas 40 have liberalized those laws. We are going against the global trend. And I know that much has been done. I know there has been much innovation and much has been done. And I commend you for that. I want to collaborate on some of the things that Michelle mentioned. But my question is really about how are you demonstrating your commitment proactively to advance and demonstrate this commitment to abortion as a human right, that what we are doing at home is echoed in our commitment globally as well. Thank you.
Hi, I'm Bettina Hager. I'm the Chief Program and Policy Director at the ERA Coalition. So as Governor Ford knows very well, the Equal Rights Amendment has fulfilled all requirements under Article 5 to be added to the U.S. Constitution, with the ratifications of Nevada, Illinois, and Virginia led off this new wave by Nevada and Governor Ford. Additionally, but unfortunately, the U.S. government continues to refuse to recognize it and publish it as the 28th Amendment. In fact, Governor Ford filed a lawsuit asking the, I'm sorry, Attorney General, I'm sorry. Doing that, obviously I know that, I don't know. I'm speaking it into being, I don't know. Yes, Attorney General, I'm sorry, that would make sense. Attorney General filed the lawsuit to compel the archivist to publish, but both the past administrations and this administration's Department of Justice fought against him in court. And he hasn't appealed the decision because it doesn't look to be going anywhere. We've also had Congress pass legislation multiple times to affirm the ERA as a 28th Amendment in the House. And in the Senate, it recently received a bipartisan majority, but we all know that there's a 60 threshold filibuster that is nearly impossible for any issue to get through at this point. So I guess and I'm so sorry about that, I feel really bad. My question, and although the Office of Legal Counsel memo, which is holding it back, was written under the Trump administration, the Biden administration, although clarifying, hasn't repealed the memo. And we're continually being told that that is what's holding it up. So my question is, what will it take in addition to everything else that we've done, the states that have ratified, the congressional votes, the 100 years this year of advocates fighting for it? What will it take for the administration to take further action? Because as my colleagues noted with the Dobbs decision, the overturn of Roe, but the courts also, the current court in their majority decision made it clear that they look to the Constitution as being interpreted by the people who wrote it. And the 14th Amendment was written well before anyone ever thought that sex discrimination would be included. So that puts a lot of our rights at risk. That's my question.
So appreciate the fact that we are still having a few moments to share and communicate and just feel all of this. It's been a long 2 hours of hearing our needs, our desires, our wishes, our dreams for rights, rights for food, rights for health, rights for loved ones, rights to live. One of the things, I'm Karen Spiller, I'm with Food Solutions New England, focusing on at least the 6 states in terms of food that's sustainable, equitable, and food that serves and feeds us all. And I'm also a member of the National Right to Food Community of Practice, which I'm very honored to be in that role as well, because it does connect everything that I believe in terms of the right. And so when we're talking about food, food is medicine, food is health, food is life. And so again, what we've all been talking about here is life. What do we need to live? What do we need to be prosperous? What do we need to be full? And I'm a little emotional right now because it's just, every right is coming at us and it's demanding us to be different. And we have to do it wherever we are, however we can. And we're asking whatever you have, whatever you can, to be able to move that, make it different for all these people, seen and unseen, in this United States that we live in. So I just want Fatima to share the requests we have, but it's like, it's on my heart. I didn't know how much it was on my heart until I stood here. But I know it is on yours as well, because you're here serving these roles diligently, tenaciously, with heartfelt mission and vision. So again, we just are here asking for, inviting you into something different.
So the question, my name's Fotini, as Karen mentioned, and I'm a law student at the University of Miami. I've had the privilege of working with the National Right to Food Community Practice for the last 1.5 years. They're a growing community working to advance the human right to adequate food across the nation. And the question that we'd like to ask you all is, given the Biden administration's September 2022 White House Conference on Hunger, Nutrition, and Health, what steps does the administration plan to take to ensure that the recommendations that came out of the conference incorporate a rights-based framework, center the voices of people with lived experiences of hunger, and address racial discrimination and the corporate control of the U.S. food system as central core elements to begin tackling hunger in the U.S.?
The two topics that we didn't tackle at all earlier have to do with ERA and reproductive health and access to food. So if maybe we want to just take a minute to address those two topics, and then the rest of them, which at least have been touched on, I think we can continue the conversation outside.
I can speak to the global health and U.S. assistance overseas. As you know, the United States is proud to remain the largest bilateral donor to family planning assistance globally, and this commitment has spanned for 5 decades. And we're committed to investing in high-quality, client-centered services that improve women's well-being, promote gender equality, and ensure women's control over their bodies and their future. And while there has been a chilling effect globally, the administration reaffirms the Supreme Court decision overturning Roe v. Wade does not change existing overseas U.S. reproductive health programming or funding. The U.S. will continue to support global SRHR programs, including through its comprehensive program in voluntary family planning, maternal and child health care, post-abortion care, and prevention and response to gender-based violence.
Again, Aaron Ford, Nevada Attorney General. Let me quickly speak to the reproductive rights and ERA issue. What I can say is, let me take the reproductive rights component first. As Attorney General, I certainly have become privy to a lot of the actions across the nation relative to attacking the autonomy of women to do what they want to with their body relative to abortion. And so several attorneys general, again, a little less than half, I'll let you do the count and figure out why, have filed lawsuits and amicus briefs in support of those who are suing states that are prohibiting abortions. We have passed laws in our state. I did not. Our legislature passed a law that is protecting, someone mentioned earlier, doctors who perform abortions that we've refused, and we've passed a law that says we will refuse to extradite people who are coming to our state seeking an abortion care. And we're doing all that we can to kind of undergird this what once was a constitutional right to an abortion in our state as and viewing it as a haven of sorts. And so I can speak to that issue from a Nevada state perspective and let you know that there are at least 23 other states that are likewise working together to try to protect this right across the board. In terms of the ERA, you are correct to say that my office, in fact, I was the majority leader when we ratified the Equal Rights Amendment. It was under my administration during that time period, and when I became Attorney General, filed a lawsuit to enforce the Equal Rights Amendment being recognized as the 28th Amendment to our state constitution, to our U.S. Constitution. We did appeal to the D.C. Court of Appeals. We lost. Have not appealed to the Supreme Court. I'll give you a reason. I'll let you figure out the reason why in that regard. But to your question, what must be done? I think some say you have to start over, unfortunately, from a ratification perspective, reaching out to states, because I can tell you this, even during the litigation component, there were some states who had ratified it previously who tried to rescind their ratification. And you're going to run into an issue of trying to get the correct tally of states, but that's one of the issues that you have to address. But and I'll be quiet right after this. We do believe that Congress, the action that they're undertaking, may give us additional support from a litigation perspective, if in fact they were to ratify or extend the deadline, because that's what the argument is, that the deadline is passed for states to ratify, including Nevada, including Illinois, including Virginia, that we ratified too late. And so maybe Congress retroactively removing that deadline gives us an additional leg to stand on from a litigation perspective. But those are a couple of thoughts on those particular issues. Happy to talk offline about it as well. But to your point, I do think it was important to address those now. Thanks so much.
Just very quickly on the, I know there was in the context of the ERA, there was a reference to the Office of Legal Counsel memo. And, we can't speak to internal DOJ deliberations. We hear the point, but I would note that we, the Department of Justice, have taken a number of actions to ensure gender equity and inclusion. And I know across the administration, for example, there was a big push to reauthorize the Violence Against Women Act, which gave many agencies, DOJ, but also HUD and others, lots more authorities to deal with gender-based violence. And the last thing I would say, just because I'll get in trouble if I don't, is I know we did also address the issue of voting rights, which was one of the questions, and I would just be remiss if I didn't say that, I think that is a huge priority for us in the Justice Department. We know that the right to vote is the right on which all these other rights are premised, the right that is central to our democracy. The questioner noted that we need Congress to act, and we have testified before Congress. We will continue to do so. That being said, although we don't have Section 5 pre-clearance, we have Section 2, which allows us to bring kind of individual actions against jurisdictions that we believe are violating the Voting Rights Act. And just on Friday, for example, we actually secured a favorable verdict in a case we brought against the city of Galveston, Texas, that enacted a plan that we argued and successfully won was a racial gerrymander. So we are using our authorities as aggressively as possible, not just under the Voting Rights Act, but also under the National Voter Registration Act, the NVRA, and the Help Americans Vote Act, HAVA. And so happy to talk more about that, and as well as many other topics that we don't have time for later on today.
Thank you for bringing up voting rights. You're right. I neglected that, and I certainly did not intend to.
And then Ambassador Taylor, may I speak to reproductive rights just because I run our nation's family planning program?
Yeah.
Thank you.
Last on 2 points. I just wanted to say, Attorney General Ford, there are 2 states that explicitly criminalize self-managed abortion, and yours is one. So I would urge you to look into that. So it's South Carolina and it is Nevada, and we're happy to meet and chat about that. I'm really, so I'd be happy to chat. And to your point, I also do want to address your comment did not really address that the law, the foreign policies that you are pertaining to, there's a full ban on funding of U.S. foreign assistance for abortion, the Helms Amendment, we all know. But there are clear exceptions in cases of rape, in cases of life endangerment, in cases of incest. And there's a very clear exception for information and counseling. And we're very gracious to the Department of Health and Human Services for issuing that statement and the FAQ on the anniversary of the Dobbs decision. But we need that from USAID directly, quite frankly, and we need more because the chill is so pervasive, especially in light of what's happened with PEPFAR. And so, again, we want to collaborate. We want to be in partnership with you, but we need to go deeper into it. Thank you.
So just one final word. So again, I'm Jess Marcella. So I'm the Deputy Assistant Secretary for Population Affairs. I run our nation's family planning program. And so I really appreciate truly all of the words around reproductive health, rights, and justice brought up in the room. I think the 3 points that I want to underscore is that we need to recognize that we have talked about our maternal mortality crisis and our reproductive rights crisis and issues around sex work. And we are not connecting the agency and autonomy of individuals in this country with respect to their bodies. And I think I am proud to work for the Biden-Harris administration because of the fact that we recognize the full panoply of reproductive health care, including abortion, is essential to determining, to allowing people to decide for themselves who they are and whom they may choose to be in the future. And so I think we have done a fair amount of work recognizing that there are restrictions. There's the Hyde Amendment domestically. Bethany just referenced the Helms Amendment. And I And I look forward to working with all of you creatively about the opportunities, because President Biden has shared his commitment on advancing sexual and reproductive health and rights for women and girls and all of their diversity in the US and across and around the world. And so I thank you for raising the issue. I want to talk to you at the reception because I think we are looking for the next round of what should be done. It is not, the irony is not lost on me that the White House released its blueprint on the maternal health crisis and how to address it on the same day that the Dobbs decision came down. And that there's a lot of work, you know, even with 3 executive orders and lots of departments who are really actively trying to coordinate in ways that I have not seen in the entirety of my career around this issue. But there is more that we should be doing, what we can do, how we frame it and talk about it. So please come find me and let's discuss more, because we are interested in taking action, because this is a priority and the president has made clear that we need a whole of government approach and beyond for this. Thank you.
Thank you for saying that out loud. I say sexual and abortion and Thank you all so much for sharing passionately, sharing your personal stories. It has been my privilege to sit in this room now twice with civil society for our treaty body presentations. And really, I think this is the heart of what we do and why we do this. So I'm really grateful to all of you. Speaking of gratitude, I would really appreciate if you would thank all of the staff at the reception, because they are staying very late to break down this room and have agreed to do so despite their own family commitments. So please join me in thanking them. And then I would just like to turn it over quickly to Ambassador Robert Gilchrist, who is our new Principal Deputy Assistant Secretary at the Department of Democracy, Human Rights, and Labor at the State Department, to close us out. Thank you.
So over the past few hours, we've covered a lot of terrain. You asked some tough questions, and let me be honest, it wasn't comfortable being on this side of the table. Exactly, it shouldn't be. But I want to end out this session by emphasizing why we are here, why we sent such a senior level delegation, why we are taking this process so seriously. Our country, the United States, strives to keep human rights at the center of both our domestic and foreign policy. For that reason, we support the vital work of the Human Rights Committee, and we particularly value the efforts of all the local and international civil society groups that are here today. You have an essential role in bringing attention to human rights challenges and monitoring compliance with international human rights obligations. In short, it is your job to ask tough questions. In some ways, your job is more straightforward when it comes to holding accountable authoritarian regimes responsible for the worst rights. Anyone would be shocked by North Korea's concentration camps or China's repression in Xinjiang. And anyone, especially the parents in this room, would feel revulsion at Russia's forcible relocation of Ukrainian children without consent of their families or government. You have a job to hold those regimes accountable. But it is also your job to make sure those countries that call themselves democracies, countries like ours, where the ICCPR's obligations are deeply woven into our constitutional system, to ensure that we have their records scrutinized. For if human rights treaties are to have meaning, they must be truly universal, and all countries must be judged by the same standard. And groups like yours have a duty to ask tough questions. Today's dialogue reminded me of our own country's struggle throughout our history to expand human rights at home, efforts that continue to this day. In the United States, some of our greatest citizens, and I would say we have great citizens in this room here today, some of our greatest citizens, true human rights defenders, were men and women who asked tough questions of their government. Frederick Douglass and Susan B. Anthony, Cesar Chavez, and Harvey Milk. By asking tough questions, these great Americans challenged our government to live up to the ideals in our founding documents, and they made our country better. President Biden believes this deeply, and just weeks after he came to office, Secretary of State Blinken said to the UN Human Rights Council, The United States does not claim to be perfect, but we strive every day to hold ourselves accountable, to become a more perfect union. We confront our own challenges openly, transparently, for the entire world to see. So today, here in Geneva on the international stage, the United States welcomes the opportunity to answer your tough questions. And we call on all ICCPR states to do the same, to take this process seriously, to be transparent, to try better. And we encourage civil society groups, both at home and abroad, to hold all countries, including our own, to the same high standards. This is how together we will make the obligations of the ICCPR have meaning and defend the cause of human dignity in every corner of the world. Thank you, and please keep asking tough questions.
Gather for a little bit longer outside.